Lift up your hands. Okay. Then we will begin immediately. And as is our tradition, we will begin with a word of prayer. I will ask Judge Justice Ougo to come here, my neighbor, to come and take us before the Lord before we begin our session this morning. Judge, karibu.
Good morning, colleagues. How was your night? Okay, I always like giving you a scripture to ponder through. The scripture today comes from Jeremiah 33:14, and I'm reading the NIV version that says, "The days are coming, declares the Lord, when I will fulfill the good promise I made to the people of Israel and Judah." So let's turn around and say, "The days are coming, declares the Lord, when I will fulfill the good promise I made for the High Court judges." Sindio? That's a declaration we are making this morning. So let us pray. Let's be upstanding. Our Father and our God, this morning, we want to say good morning, Lord Jesus. It's a day that you've given us. Your word says that we should rejoice and be glad in it. We thank you for the night that has passed and the day that you have ushered. What a bright, beautiful day. It reminds us that you are not only sovereign, but that you are in control and that you sustain your universe and that you are sovereign over our lives, each person in this room. So we want to say thank you. When we started yesterday, we committed this conference, this summit into your hands, and we want to give thanks because you took us through the day well. The presentations that were made were useful to us. They left us with materials to think about on how we should be a part of this nation as a high court, and what a privilege it is to serve as a judge. But we recognize this morning that you are the most high judge, the judge whose justice cannot be even questioned. So as we sit here this morning, we sit as your children, as your servants, serving in the High Court, and we bring ourselves before you once again this second day of the summit. You already know what the day holds, so we can trust you that from now, when we start, up to the afternoon when we visit the children's home, to the evening when we have our individual fellowships, you will be with us. So Lord Jesus, we want to commit this day and the entire activities of the day into your hands. And as we sit, Lord Jesus, we sit at your feet and thank you for the word that you've given us this morning, that the days are coming, declares the Lord, when I will fulfill the good promise I have made, the ones you have made to the High Court. We declare that we'll receive them. In Jesus' name we pray. Amen.
Thank you, Judge Ougo, for taking us before the Lord. The principal judge, my colleagues, judges who are here, and all the participants of this forum, I wish to take this opportunity to remind us about the theme of this year's workshop, which is upholding the human dignity and the ethical leadership. Yesterday, we were taken through the subject on the ethical leadership. We were also taken through the scorecard of what Kenyans think about us, judiciary. And I think we all saw what people think about us. And at times I tend to think that sometimes the judiciary sometimes is charged very harshly. Because I was wondering if this is a standard that the judiciary has been charged, and it was found that we are at 50%, which is bad. We are doing very badly in terms of integrity index. What about the other arms? What about the executive? What about the parliament? If we are at 50, what about the other arms of government? And are we actually charged the same way? It's like sometimes judges are charged in a different standard than even the others. But when you look at the Chapter 6 of the Constitution, Leadership and Integrity Act, Leadership and Integrity, it appears that it only applies to judges. I don't know whether I'm wrong. I don't know whether it also applies to all the other arms. Because when it comes to judges being appointed and the amount of scrutiny that the judges are being subjected to, when you compare it with the others, do Kenyans also subject the other arms to the same scrutiny that judges and judicial officers are being subjected to? And if not, why? So as we ponder about that this morning, we are privileged that we have a constitutional expert, Mr. Bobby Mkangi, who is here with us. He's going to take us through that chapter of the Constitution, Leadership and Integrity chapter. It is a chapter that has been litigated upon in our courts. It's a standard that the Kenyans thought that for us to sanitize the way we do things, we have to subject each and every person into that chapter. So when we talk about public trust, when we talk about respect to the people that has put us in the positions that we hold, whether it's a role, judicial role, or other roles in the leadership, in the executive, in parliament. Do we exude respect, honor, and integrity, selfless service, honest, discipline, a commitment? Or as Kenyans, we are treating this chapter as a mere suggestion? Have we really actualized this chapter to make our aspirations as a people come through? So allow me, colleagues, to welcome our speaker for this morning. We are already almost 30 minutes late. I will give him slightly, maybe over 45 minutes, around 1 hour, to come and make the presentation to us. So I think the bio is on your screen, so I don't have to go through it. So let's put our hands as we welcome Mr. Bobby Mkangi. Karibu. No. You will go up there. Want everybody to see you as you make your presentation. It's okay, you can move around. Yes, karibu sana.
Principal Judge, and respecting all due protocol. Good morning, ladies and gentlemen. Wanaostahili ama wanaostahiki, shikamoo. Shikamoo. Na kwa wale ambao mvi zao ni za vijana wa kitambo. Saseni. Thank you very much. It's a great honor to be before you this morning. I thank you for inviting me to come and address you during this quite auspicious occasion, of which I would like to begin by congratulating you as the institution of the judiciary, as the institution of the state, and particularly the High Court, for imagining, because that's one of the key terminology that we are going to unpack today, for imagining this annual Human Rights Summit. Because I think in you and us, and to the larger extent, extrapolating all Kenyans, if we sit together at the end of every year and address ourselves to how we have performed through the year and through other years, pick and learn from each other, draw the lessons that we need to, because those are going to be the guide to us as we continue serving Kenyans. I think that is a very, very honorable venture. And that's why I feel quite honored and humbled to speak to ladies and gentlemen of your stature, of your honor, and of the caliber that Kenyans have accorded you. And I feel particularly happy because when the Constitution of Kenya 2010 came into being, one of the things that Kenyans imagined was that today, being 15 years since they promulgated the document, there's a way they envisioned their lives would be. And as somebody, as you may have seen in the bio, somebody who was humbled again and honored by Kenyans by requesting me to serve as one of the members of the Committee of Experts. And we are going to see what our mandate was. There are those corners, nooks and crannies from which certain decisions came from. And as time has been flowing or passing by, and for those of us who are in those rooms, in those spaces, observing, participating, sometimes fighting, not physically, but verbally, so that each word, each comma, each sentence, paragraph that we have in our document today is as is unfortunately, in my observation, sort of getting lost. And we are getting to forget where some of the inspiration of these sentences, some of these words came from. And that's why I feel happy to be with you this morning, so that we can address ourselves and remind ourselves, because you as judges, I'm actually very sure that you know much more than I do at this juncture, because you work with this document, the Constitution of Kenya 2010, and the laws that have been birthed through it on a day-to-day basis. Digest, unpack, disambiguate, interpret, and decide what Kenyans thought and envisioned and imagined. And so today, as we talk about the ethical reimagination of this important document, with a subtitle of Unfinished Business of Chapter 6. I'll want to, sorry, if I can get, okay. Sorry, as the slides come through. I'll want to use the outline that will appear to discuss this document, or to go through our discussion today. And I'll want us to, because we are judges, or we work with, as I said, these pieces of legislature, the Constitution on a day-to-day basis. And so when this topic was shared with me, I thought, what would be the best way of addressing this issue? And I thought the best thing to do would be to go back to the crux of where Kenyans came from, and then address ourselves as to whether we have shown fidelity to that imagination, so that now we can reimagine. Because when I looked at the topic, I asked myself whether I am being asked to discuss the ethical reimagination as of 2010, or the ethical reimagination as of today, the 9th of December 2025, going forward. And I thought the one for today going forward is more important, but cannot be addressed before we look at what the original imagination and reimagination was. So that now we can answer ourselves, like we were challenged earlier on, whether the 50% mark that Kenyans have given us is fair or not, and whether we can do something to improve the same. So before I go on, 2 disclaimers, as they do in Hollywood. 1, no character, no person, place, or incident in whatever I will discuss reflects any person, character, or incident in real life. So that's my first disclaimer. So if we are discussing and you think, kwa nini huyu anaongea juu yangu, I'm not talking about anyone. Eh? Are we okay with that? That's the first one. And the second one, no animal was hurt or injured in the making of this production. And so with that, I want to set off. And as I was saying, I have 3 or 4 points I want us to belabor, and that will be the outline of my discussion. And first, it will be a brief history of the Constitution. And then particularly, why we want to discuss that is, as I was saying, we cannot reimagine going forward before we remember what the original imagination was. And then I also want to briefly touch on what our mandate as a committee of experts was, because it's very important as to what the final document, those 7 articles between 73 and 80 of our document, why they are as they are today. Many a times we'll meet people and they'll tell us, especially those of us who are in the committee, nyinyi muliandika hivi. And especially when things go wrong, that's when they point fingers at us. Eh? When they feel there's something that, but when things are okay, we've also met all sorts of and manner of people who will claim that sentence was mine, that paragraph was mine, that chapter was mine. Haven't you heard the same? In fact, when we meet, some of us as the former members, one of the jokes we crack is that it is us who were in charge of the final language who never come out to say, I wrote this, I wrote that. Rarely do I hear my colleagues doing that, but I've heard it being said by other people. And so I feel it's important to address that just briefly, and especially as hinged upon this chapter. And then the other thing is the evolution of the chapter specifically. And why I want us to address that is because it's going to bring out certain nuances and perhaps and hopefully show us why we're having the challenges that we have today in implementing these 7 provisions in our Constitution. And then finally, there is a question of unfinished business. And before we leave, we'll want to ask ourselves whether it is business that has to be finished, or it is business that is, in terms of chapter 6, whether it is business that should remain unfinished into the future. And so let me start with a brief history, but I will not, I will also not belabor this because it's something that I'm sure you are very familiar with, but I thought it would be very important to mention it. Let me start with yes. So when we think through our constitutional history, most of the times we start with the Independence Lancaster House Katiba, and in 2 or 3 days' time, we're going to be celebrating or marking the 62nd Jamhuri Day. Is it 62nd or 63rd? 62nd? 63rd. 62nd. My math is going into disarray. 62nd, yes. So we are going to be observing that. And primary in how we got what we call independence was that document, which we now call the Independence Constitution. But again, interesting where the imagination or the reimagination of who as Kenyans we were and where we wanted to go, we take cognizance of the fact that immediately after we got that Independence Constitution, and for those of you who are familiar with the history, and I'm sure most of you are, you remember that it was a constitution that was made and accepted with the intention, and I must say constitution, quote and unquote. But for those who agreed into having it, at Lancaster, the Jomo Kenyattas, the Oginga Odingas, and with the advice of very eminent judicial personalities, the advice of the late Thurgood Marshall, who was advising the team at Lancaster. It was agreed to what these people want. You don't want Majimbo, just agree, just agree. Once you have your independence, you can do what you want. You can change whatever you want. You can amend what you want. And that's the journey we start seeing from 1964. And that's where, as Ngugi wa Thiong'o said, the rain starts beating us. But there's a question of whether that Lancaster House document was the imagination of Kenyans. But the drama, the political drama that we start seeing from 1964, that eventually pits Oginga Odinga and Jomo Kenyatta into different political regions, is what inspired. Because I know when we start talking about constitutional changes in Kenya, we like going to the late 80s, 90s. But I think the seeding into there's something wrong with our constitutionality begins with that period when the politics started going wrong. When the dignity of Kenyans started being affected negatively. And we have to, as we discuss this, and I'm happy I had, and looking through the program, what you discussed yesterday, the centrality of dignity the dignity of Kenyans. Because what we read through our history, that mashamba yalinyakuliwa, who was betrayed, which community was mistreated, all that is what gave birth to the beginning of Kenyans feeling and thinking that we actually need another defined constitutional order. And so the corruption and bad leadership is what took us and began this journey for clamor for reimagination. And you can fast forward, and we know all those changes that happened in 1969, with the amendments that took place in the 70s, what happened with, even when you read the reasons why, very, very popular and good provisions like Kiswahili being the national or a national language came into being. So we come later into the future and to hold forth to it and protect it. But when you go to the original imagination, totally different. But let's not belabor that. We know the changes that took place, the amendments that eventually made Kenya a single party dictatorship. And the clamor that we saw in the 80s especially, we are still mourning the late former Prime Minister of Kenya, Right Honorable Raila Odinga. And we cannot have a discussion around the Constitution of Kenya 2010 without invoking his presence. And most of why I remember this is we know the work he did in the 80s especially, and beyond that. And many other Kenyans that lost life, limb, and property to ensure that this document is as is today. And so, 92, we have multi-party democracy coming back, and that is when there is a first trigger of Kenyans now are reimagining. They are off the blocks of reimagining their constitution. The Guy team comes in place in the late 90s, early 2000, with the Constitution of Kenya Review Act and the 27 commissioners that were given the task of drafting Kenya's new constitution. And we remember the first 2 years, what they did, went around the country, almost each and every ward, every constituency, collected the views of Kenyans, and deciphered the same, and eventually interpreted that into constitutional language. And that's why we have the Guy draft of 2002, the first raw draft of what the imagination of Kenyans, of what or where Kenya should be headed, came out. And then we have the Bomas, or the Constitutional National Conference, which in 2004 gave birth to the Bomas draft. And we know if I may borrow from our Nigerian brothers, the Wahala that took place between Bomas and eventually the Wako draft. The proposed Constitution of Kenya, 2005, which made bananas and oranges fight. How many of you decided not to eat certain fruits? Because those of you remember the debates? Some people stopped eating bananas and others stopped eating oranges, isn't it? That's how tough things were. That's how. So we had that. We know how it went. Fast forward to the post-election violence of late 2007 and early 2008. And that's the transformative justice, transitional justice processes that began or were triggered by the PEV are what gave birth to the committee of experts. Remember the itemized agenda items, the COE coming under item number 4, where there are the long-term agenda. You know, there are those for seasoned deceased. How do we deal with displaced persons? And this, again, we must remember, was a civil society agenda, because the first 3 agenda items were more around the politicians. We know our politicians, how they think about their things first, isn't it? Yeah? And so, fortunately, we had the civil society and other observers who said the post-election violence did not happen just because an election went wrong. But it also happened because we have long-term historical issues that had not been addressed. One of those, as an end in itself, was in capturing the reimagined Kenya as was proposed under Bomas, under Guy, by Kenyans, as was rejected in the 2005 referendum. And so we must conclude that process. But in itself, in it being an end, it is also a means. It is also an avenue towards capturing, entrenching those issues that have been eating us since not only 1963 or 1964 when we started unpacking the independence constitution, but also into the colonial project and into the coloniality of what Kenya is today. And as we are discussing the dignity of Kenyans, human dignity as a pillar of constitutionalism, we must also address it within the current coloniality. And in coloniality, I mean, we are going to celebrate 62 years. But how independent are we? How free are we? How dignified are we? If our leaders have to board flights to go to those lands of people who caused all this, to go and agree about things about us here. Dignity. I'll keep impressing upon dignity. Dignity. And I'm happy that it is a central issue in this year's summit. So we prod our minds around that, because the dignity of is not only around chapter 4, and chapter 6 captures that very well, but in the broader aspects of how we think around human dignity. And we as Kenyans are colonial, post-colonial, some people would say neo-colonial, some people would argue it's free, I would argue otherwise, maybe partially. But that aspect, I think, is very, very important. And then finally, in 2010, August 27th, at Uhuru Park, through the leadership of the late President Mwai Kibaki, Kenyans got the document that they wanted. And the journey began into reimagining a new Kenya. And so we ask ourselves today, is the dignity of Kenyans better or worse? Or where is it? Even beyond ourselves as an institution, as judicial officials, as judges, and as servants of the people. I think these are very, very important questions that we must, as we go into breaking for the holidays, look into. How expansive is our mandate in our personalities as judges, as judicial officials, as an institution, and as a country? since August 27, 2010, when you said we give this document unto ourselves and to the future of Kenyans. And we'll see where that draws its importance. So very briefly, our mandate as COE, and I said I want to discuss this because it ties to and answers the question around also who are the framers, because I'm sure it's a question that also you have addressed yourself to when you're interpreting the ambiguity of this document. And as I was alluding to earlier, for those sentences or those provisions which, as Obama said, a good constitution speaks to itself. You almost, if I would imagine how we would say it nowadays, it's clear, pap. Paraphrasing him. When we are trying to see where this document comes from, and when I hear of many people discussing it, as I said, when things are not clear or not right, the finger is pointed at the COE, isn't it? But when things are okay, we lay claim. Everyone lays claim. But as we said during the process, we knew we were the punching bags of the process, so we take it. And part of our mandate, which was derived from the Constitution of Kenya Review Act of 2008, was basically to lead and steward the finalization of the process. But more importantly, is bullet number 3, review the drafts. Could I have a microphone? If you don't mind me roving around, is that okay? Okay. I might be a preacher one day, so let me practice here. So in reviewing the drafts, so our mandate was restricted to looking at what Kenyans had agreed upon and what was contentious in the constitution-making process between 2000 and where we were. So the important documents that were specifically mentioned in the CKRA 2008 were the guide draft. We have to address ourselves to the guide draft, the Bomas draft, and the attendant documents that led to, and processes that led to the WACO draft. That's a proposed Constitution of Kenya 2005. And receive views from Kenyans around what would term to be contentious or what was agreed upon. And what is important about this particular aspect is that in our judgment, the leadership and integrity chapter was a chapter that had been agreed upon by Kenyans. Because also, another document that we were asked to look into was the final report of the CKRC that was produced in 2005. I'm sure some of you have seen it, that big blue document. And that's where we go and find the views from Kenyans. And when you look at what Kenyans said about the leadership and integrity issues and chapters as we go to the evolution of the chapter, is that these are not provisions that were imagined by the COE. That's the first point I wanted to make. Because people imagine this is something that came from the COE. And also, what was in the previous drafts was not something that was imagined by the CKRC. Because the CKRC was just interpreting and putting into constitutional language what Kenyans had told them between 2000 and 2002. So the leadership and integrity chapter is not anything that fell from the sky, but was something that Kenyans proposed. And I think when you look at the report, you'll find that it's almost everywhere the CKRC went, that Kenyans spoke of integrating, entrenching, infusing integrity and ethical exercise of public offices, because that's where the concern was. And why was this the case? Because, as you know, and as of what you find in constitutional text, is a response of the experiences that a populace or a people have had over the years, isn't it? So you'll find, if you want to look through the history of a certain country, if you look at their constitution, it can actually tell you the nuances of the experience of that nation. Like I recall, when you look at the Mozambican constitution, you'll find, I don't know whether it's still there, but there was a provision around what time you could visit somebody at their homes, that you can't go to their home beyond this time. And so you'd want to ask yourself, for instance, if you're in Kenya, why should this be a constitutional provision? This looks like just a civil thing, isn't it? Don't call me after this. It's not okay for you to call me after. But it is there. But it's because of their history. That's why they found the importance of putting it there. And so for Kenyans to say we must have leadership and integrity, it was because of that history. And going back to the colonial state and to what they had experienced between 1963 and 2010, that they said we must have a standalone chapter that speaks to the issues of integrity and the ethical practice by its leaders or its servants. And also they had gone through we must also not forget that we had documents, pieces of legislation that preceded the Constitution. Public Officers Ethics Act, the Economic Crimes Act. Those were documents that were already there. The EACC, as is today, we had previous modulations of this institution. So the other thing that Kenyans wanted to do was to entrench, because they knew and they had seen what had happened to what used to be the Kenya Anti-Corruption Commission, and then changed into, I've even forgotten the names, but those of you who are around can remember, isn't it? And where we'll wake up and we'll be told that body has been dissolved, the chairperson has been sacked. But Kenyans had seen the importance of that, of those pieces of legislation and the institutional approach to first infusing ethical behavior into public service, into state service, but also fighting the negative externalities that came out of that. So the primary focus was to entrench ethical behavior, because most of the times you always think of, and this is the challenge again, that perhaps institutions like EACC may have. Because when Kenyans think of EACC, they think about first fighting corruption, isn't it? How many people have you jailed? How many people have you prosecuted? But if we go backwards, we think of what positive changes have happened into our institutions to make them more ethical. And perhaps also unpacking the term. I didn't want to belabor this because I know you discussed it yesterday. When you think of the ethical aspects of it, And when you look at Article 73, it actually goes beyond you practicing or exercising yourself in the way your call of duty requires of you. Because there are provisions which talk about even your private conduct. True or not? Even how you carry yourself privately. So Kenyans, in some way, did not only want you to be ethical between 8 and 5. Or when you're on the bench. But they were saying, and they have been saying, and the document they came up with saying, the way you conduct yourself, even in your private imaginations, must be in ways that respect them. Because when you respect the people, as 73 says, those principles, if you respect your office, you infuse public confidence. But above all, you dignify Kenyans. One question I like asking people, especially those of us who've served within government precincts and state institutions, do we say, because I hear many people say, I work for the government. Hii inachokoza tu. So do you work for the government of Kenya or do you work for the people of Kenya? Because it makes a difference. Do we work for the government of Kenya or for the people of Kenya? Let's ponder as we move along. So the point I want to mention around how the chapter, as you can see, it danced around, but around the WACO draft. The WACO draft removed the chapter. And I think there were just 1 or 2 provisions thrown and hidden somewhere here and there. And again, the other thing, let's also remember, we were not writing this document in absentia or in a vacuum. We knew that the Ugandans in 1995, when they came up with their document, their chapter 10 had a leadership, although it's not a leadership and integrity chapter, but a leadership code of conduct. So that also gave us an idea. But we expanded it. So by the time the imaginators of WACO thought this was not important and caused that document to be rejected. So when we came, and the first document that we came out with, the harmonized draft, in late 2009, because what we were supposed to do was look at what is contentious, look at what is agreed upon, and for those of you remember the contentious issues, devolution, and not the principle, but what form, the form of executive, judiciary, I think it was around transitional issues, and bicameral government, but not the principle. I think what we deciphered was Kenyans had agreed on the bicameralism, but the form was what was not agreed upon. But now when we looked at these other documents and looked at WACO, our synthesis was that when we go back to the CKRC report and these other documents and what Kenyans had said, we reintroduced, because the last draft was WACO draft before our draft, the harmonized draft as per CKRC. And after also receiving views from Kenyans. And we brought it forward to chapter 6. Not to say that chapters and how they are arranged sort of bequeath a hierarchy of importance, but just in bringing some elegance, drawing upon the principal issues first, and then the institutional formations later. So we brought it up to chapter 6. It was lengthier than what eventually is today. Why? Because the Parliamentary Select Committee, the Joint Parliamentary Select Committee, that was headed by Honorable Abdikadir Mohammed at that time. When they went to the famous or infamous Naivasha, one of the chapters that was mutilated was this chapter 6. And they were not supposed to do it, because what they were supposed, as per the law, to address themselves to were the contentious issues. Devolution, the executive, bicameral government, and the transitional aspects. But they went and revised the whole document, including chapter 6. And what did they do? They removed so many aspects of the document, including killing what Kenyans had wanted, the institution that was going to oversee the implementation of this chapter. What now we have as the EACC. And so Article 79 was actually, we as the committee of experts, going a bit rogue. Because we knew that if we are going to have the document with the principles alone, and as narrowed as they had been, and we had a meeting with the select committee afterwards to ask them about the inspiration of the changes. And with the EACC, they said corruption is not a going concern. So we don't need a commission. In fact, they said there are many commissions in the drafts. And to some extent it was true, isn't it? I think initially there were like 15, 16. So one of the ones they kicked out was the one for corruption. They said, corruption itaisha. Corruption itaisha. So we said, so why can't we have it and then have a sunset clause? And they said, no, not at all. We don't want the EACC or an institution for dealing with corruption in the Constitution. And that's why 79 appears as it is. It's not, it doesn't create the institution per se, but directs Parliament to make sure that it creates the institution. That is how EACC got its comeback. And so as we are thinking through this, one of the things I want to come out, and I hope has been coming out, and it's been noted by Kenyans, including the surveys you've been dealing with, the survey in the strategic guide of perceptions by Kenyans, political interference has been prodded by Kenyans as the biggest challenge. True or not? Political interference. And you can see where that interference started coming from, even in the creation of this document. And that's why, as we discuss the document and the chapter, we must lay emphasis on how, especially we as the institution that is called upon to be a referee, an arbiter, when there is conflict around it, around the chapter, why some of the things as they happen today are. So the politicians, right from the get-go, as the Americans would say, did not want this chapter first. But when they saw that Kenyans were keen on it, they said, okay, we can have it, but we don't want an institution that is going to follow us around. And I'm saying follow us around because, again, I think this is not... Anyway, I gave a disclaimer. No real person, no real event. But we know where most of the fingers are pointed at. Where there is always smoke, isn't it? within the political ecosystem of our country when it comes to and corruption not only in terms of pinching from the cookie jar, but corruption also in terms of how we dignify or indignify Kenyans comes a lot from the political ecosystem. And so, finally, we ask ourselves, as the topic addresses itself, is this unfinished business? And in answering this, I would like to ask, is it business that should be finished? The chapter 6 issues, will they ever be finished? Will they ever be looked at in the way the politicians looked at them in 2010, early 2010, when they went to Naivasha? And they said, Ufisadi, we are going to clean this thing. Why should we have a commission? It's going to end. It's a seasonal thing. Is it a seasonal thing? 15 years now. And 15 years, and also going back to 2003, when the ethics and what's a full citation? The Economic Crimes Act. When you have the Public Officers and Ethics Act. So this experience and what we have today, is it unfinished business? And if it's unfinished business, are we on the wrong track or the right track? And that's why we have to look at what was the imagination. We're going back to the first imagination, and we've been talking about it. But I think the first thing we have to remember is that the Katiba or the Constitution for Kenyans, in as much as the process of making it at some point was an end in itself in getting the new Katiba, but that was not to finish the business. It was as a means, it was as a roadmap, isn't it, to a certain end. And what is that end that Kenyans thought about? Kenyans, like most human beings and other human beings, they also want to drive SUVs. Or they want to be driven in SUVs. They want to live in mansions. They want to take their children to schools where they will get the best education. They want that when their children and themselves suffer the misfortune of ill health, to receive the best medical and health services that they can. They want, and especially during a season like now, where we are going into holidays, they want to go and mingle in the beaches of the white sands of our Kenyan coast, if not in other jurisdictions. In other words, the Katiba is a means to the material ends of Kenyans, to improving their wherewithal. And that's why I prodded this paragraph from the preamble. We looked into the history, what was the inspiration? We honor those who fought for the dignity, because when those who fought for freedom, they were fighting for what? You fight for freedom so that you can be dignified, isn't it? They were fighting for that. But eventually, when you look at how the paragraphs go, committed to nurturing and protecting the well-being of who? The individual, the family, communities, and the nation. And then we have Article 1. Why are the people sovereign? It's the most dignifying article in the Constitution, isn't it? The mwananchi is sovereign, but not only as an individual, but that's why you say the sovereign power belongs to all the people of Kenya, isn't it? As a unit. And then the ecosystem, when you look at how we are addressing or how we address our republic, the country that is Kenya, it's a sovereign republic. It is an independent republic. So we as state officers, when we are making decisions, do we make decisions that hold forth to this provision? To the dignity of Kenyans in terms of this is a decision that will ensure that we push the country and the people of Kenya further in their imagination of being free and independent. And then in that sovereignty of republicanism, it is said that the DNA of it, the nitty-gritty of what makes it a sovereign republic, is Article 10, which is the DNA of it all. And so in that, Kenyans came up with a formulation and the understanding that the best way of achieving that imagination of being a dignified Kenyan is through the creation of institutions like the EACC, like the judiciary, Article 1, like Bunge, the executive. So there is that indirect expression of their dignity, but also there is a direct expression of it, which we've been seeing in the past year coming out quite clearly and evidently. But they also understood, and that's why chapter 6 is there. They were as wise as, is it Plato who imagined of the philosopher king? It's Plato, yeah? Issues of the virtuous man and woman. That those institutions, just like a car, the speed of a car or how a car or vehicle will be driven will be as good as the what? As the driver, isn't it? Even now, as we are seeing in the US with the way more self-driven or driverless, cab services. And we are seeing that they are also as good as the algorithms that are fed into them. They are not perfect. They are better, but not perfect. So Kenyans also understood, and through their history, they had seen, you can create institutions. Every morning you wake up, create institutions. But if the people who are in charge, the people who are running those institutions, do not meet the meter they are provided, they don't meet the master, then the institutions are useless. And I think that has been also very much alive with us, especially not only in Kenya, but globally, when we look at our politics, the global politics, geopolitics, especially from 2008. Let's start with 2008, going forward. But Kenyans were alive to that. And as I was saying, that's why there is chapter 6. And as Justice Lima was asking earlier, is it just the judiciary that is put to that level of scrutiny? and not the other institutions or other arms of the state. And I think there is a particular reason for that. Because I think Kenyans also understood and sort of had the premonition, if not the prognosis, that bunge wataanguka. Wabunge wataanguka, isn't it? The executive, as is cultural, will try to, stretch and flex their muscles into other areas that they're not supposed to. And they knew the person or the institution that can, whenever this happens, can slap the wrist and say, hey, remove your hand from here, go back to your lane, was the institution of the judiciary. But again, they had seen the history and why that previous republic had failed, and especially with these two other arms not behaving as they were supposed to. And they knew that if we have a judiciary that can help referee around the conflicts with fidelity, then in as much as these other arms or institutions fall off the way, we have this institution that can bring them back to file. But again, for that institution to work properly, it must have men and women who reflect 73 to 80. And that's why there is more scrutiny. I agree with you. In fact, you're the only institution, if you recall, that there was a vetting process. In fact, in the transitional clauses, the heaviest issue that we dealt with was around how we are going to treat the judiciary and what Kenyans were calling for. In fact, there are those who are extreme to say dissolve it as it is as a whole, as of 2010, and recruit afresh. You recall that? Yeah? They are saying we may deal with this, wabunge, they'll come. We always deal with them, kwa debe, isn't it? We always deal with them at the ballot box, including the executive. We can deal, but these are the ones that who serve a very important role in ensuring good manners are instilled. If of themselves are not good mannered, then the entire edifice falls apart. And that's why there was very particular focus on the institution of the judiciary. And so Kenyans, if I finalize this imagination, they knew that the Katiba was the means to this lovely country that was going to satisfy their social, cultural, environmental, economical aspects of their lives. And as I say, let's not imagine that some of these things, it's only us who want them. Every Kenyan wants to be in a Range Rover. Or most. There are others who are philosophically directed otherwise. And so the question they ask is, why can't I be in a Range Rover? Why can't I live in a mansion? Why can't I be, when I'm ill or my child is ill, be at Nairobi Hospital private wing? Do you imagine some of these things are only God sent for some of us? No. Kenyans also want those, and they want this project to ensure that as many as Kenyans can achieve those. And they know that they can do it if they have competent men and women driving the project. That's why good, ethical, servant leadership, and that's why, again, when you look at 73, there is a principle that, and I saw the immediate former Chief Justice of India, CJI Gavai, when he was leaving, he said that he used his position and this a few weeks ago, his position as a means to service, to serve the people of India and humanity at large, and not as a means to power. Not power to rule over others, as he said under Article 73. So for us also, as judges, as people who Kenyans have said, we are giving you the opportunity to serve us in this very, very honorable position. Is it a position for us to serve Kenyans, to empower us to serve Kenyans? Or is it a position that empowers us to rule over Kenyans and to serve ourselves? That's why this chapter, and 73 especially, goes into the individual person, where Kenyans are saying, in this project, it's not only institutions, but the people who are serving in those institutions are as important as the institutions themselves. And that's why even now globally there is a debate. Which is the best political system? Is it the new liberal order? Is it the Chinese way? Is it the Russian way? Is it the American way? Because people are now seeing that, wait a minute, we used to be told that it's only a democratic that can deliver this. But we're also seeing other entities that don't have those particular attributes delivering the same. So what is the difference? And Kenyans had an idea around this way back 2000, that the people in these institutions are the crux of the matter. You can create the fastest Lamborghini, but if you give it to a slow driver, it will be as slow or slower than a bicycle. You can create the best football, but there's a difference when you give it to Lionel Messi or Cristiano Ronaldo and you give it to me, isn't it? So that's what Kenyans were drawing themselves to. So chapter 6 is a portrait of the strict accountability. And that's why it goes to that very strict sanction of saying that ukikosea, ukipatikana na makosa katika huduma yako kwa umma na kwa jamii, endapo taasisi ambazo zina majukumu ya kuhakikisha kwamba mtu ana hatia au la, yatakukuta na hatia, basi unaondolewa kabisa kikamilifu kutoka orodha ya Wakenya ambao wanaweza kuwahudumia Wakenya wenzao. That's why there is that. And you know, through your good institution, there are some people now who are living through this reality, isn't it? Time? Oh, okay. There are those who now we know, they were in public office, they were in state offices, but they have been taken through these processes. This 75, Article 75, and now are bad. There are questions around the strictness of this measure. Why was in there a sunset clause? Why say you are bad, you serve your time, and then get rehabilitated? Just the way people are convicted and they go and serve their sentences, whatever it is, and then after that you say, I've served my time, you are rehabilitated back into community. But you can see Kenyans were very strict. They didn't say you are prohibited for 10 years and then come back, or prohibited for 5 years. And I think there was, I don't know whether Well, it was a proposal for an act of parliament. I'm trying to recall that certain quotas be created. And say, oh, after 10 years or 5 years, somebody can come back. But what does the Constitution say? It just says you're prohibited, isn't it? Not for 3 years, not for 4 years, forever. Don't come anywhere near us because you have indignified us. Huh? The way you've conducted yourself is not how we ourselves, we as Kenyans, see or interpret our dignity. And that's why we don't want you anywhere near our dignity. You can go do it in your private ventures, but not anywhere near our public ecosystem. And so why have we seen these challenges? And in looking at this again, I won't belabor, because again, when we look at the strategic guide, it's very well summarized, the challenges, you know them. I think you addressed them yesterday. But I just wanted us to look at them because they're the things we are also trying to unpack when we are dealing with our solutions, when cases are presented before us. Those are the type of things we are trying to unpack, and the challenges that we also come across, where you find the misuse of office, broadly corruption as interpreted or as provided in the pieces of legislation. And you find some of the root problems are systemic, to the extent that they have now become cultural. I've put there kakitu. Nowadays, you can't go anywhere before somebody asking or saying, unatuacha hivyo? Si utuachia kakitu bwana. Isn't it? Part of it is okay. It could be umeenda nyumbani, they're young people and they just want to have a nice soda. You know, there's part of it. But we know where kakitu. And I laugh, I make the joke that even corruption has suffered the antecedents of a falling economy, and what used to be kitu has also become kakitu. So it is also part of the kadogo economy, from kitu to kakitu. But there's that cultural aspect. And it also affects because, before I go to the second bullet, the third bullet, because we are dealing with people who are presented before us and then you are accused. Mtu wetu ameshtakiwa. Where corruption, I'm paraphrasing the philosopher, French philosopher Jean-Paul Sartre, who said, hell is other people. So for us, in Kenya, corruption, bad leadership is other people. Because when somebody from our people, my person is touched, what do we say? Anaonewa, isn't it? So you as somebody who's dealing, and your fingers are being pointed at you, and you're being imagined to be part of a schema of punishing watu wengine, isn't it? It creates a big problem in also how we define, how we understand bad leadership, how we disambiguate what behaviors are good, what manners are good, and what manners are bad. And most of the times they are only good. Corruption is accepted if mtu wetu ndo ameifanya, because alileta maendeleo kwetu. In fact, I'm sure you've heard where people say this person went and served in this big office, and this person was very stupid because hakukula. Isn't it? This person did not munch as they're supposed to. But when it's somebody from the other ridge who munches, we are quick to point fingers. So now that creates a problem in how also we deal with this beast or animal at a societal level, because that's where the root of the problem is. If I go to bullet point number 2, the Bwana Bi Mkubwa Afande syndrome. As we see, chapter 6 is very much individuated. You as a judge, this very big honorable position, do you dignify those you work with, your colleagues? And your colleagues are not the judges only. Your colleagues are also everyone who works for the judiciary. Other Kenyans. Do you conduct yourself in a way that dignifies them? Or you feel that you must function within the parameters of the colonial element of how leadership must be conducted and what was bequeathed to us, the Afande, Bwana Mkubwa, Bi Mkubwa aspects, of which we must also understand, if you follow the trends, read the literature of those who gave us these processes and systems, they are changing. But for us, we are still beholden to the culture, a 60-year-old culture, because we feel, you know, my parents struggled to take me to school. I worked hard. Nikasoma na karoboi. Do you know what time I used to wake up to read so that I could go to university, get a university? Did you know what I did? And now I'm a judge. You must treat me as a judge. Sasa mimi ni mtu mkubwa. Yeah? There's that syndrome. I remember I met a member of parliament one time at an airport. I said, oh, Bwana Mkangi, how are you doing? So where are you now since you left that big position? Big position. Is it a small position in service to humanity? However, we know that those who have been given much responsibility, or to those who much has been given, what is expected? Much. And much what? Much dignity. Because it's in how we dignify ourselves. If we let this Sir, Madam, Bi Mkubwa, Bab Kubwa, as the Tanzanians say, you know, I think if we let some of these aspects drop off our attires, we are probably serving chapter 6 better. And in how Kenyans imagined it. If I may use and borrow the words of Lady Justice Mumbi, political hygiene. And we mentioned that, and our document, the strategic guide, speaks to it, how the politics is conducted. Very inadequate political hygiene, or lack of it totally sometimes. I think that's a huge, and political interference in our cases, true or not, especially by the time they get to us. And the imagination, or what Kenyans can see, and especially the last point, selective justice. You know, I think sometimes we sit in our high offices and we think, sometimes I think that we concoct certain lies and formulations in our minds and then expect or think that it's every Kenyan who, if you convince your mind that this is the right thing, if we cook this story and sell it to them, they are going to buy it the way we are imagining it. But Kenyans are not fools. There's that saying, you can fool all the people all the time, but you cannot, you know it, eh? So Kenyans can see. It's not so difficult. They can take apples and put them aside. They can see where the oranges are going. They can see where the chapatis are going, where the leftovers are going. And by the time they start saying there is selective justice, it's because they are seeing certain patterns. It's not out of the blue. They're asking themselves, why are the cases around certain personalities going this way? And we know where these personalities belong, or how they talk, or how they conduct themselves. And these other ones are going this way. And we also know the antecedents around these personalities. But I pose it as a question, is there selective justice? And if it's there, where is it rooted from? And it has a strong connection to that political hygiene. So as we finalize the reimagination, because now we have looked at the imagination of 2010, of 2000, of 1964, and the beautiful Kenya where every person's well-being, the family, the individual, the community, and Kenya. And well-being means what? That's the material aspects of life. That's why every year when we are doing a scorecard of where have we reached in the implementation of the Constitution, my answer is always, look at the lives of Kenyans as of 2010 and the lives of Kenyans as of that anniversary. And ask yourself whether as of the anniversary the lives are better or not. And there lies your answer. Because the Katiba was a means towards the improvement of the well-being of Kenyans. So if their well-being, if they are poorer today, if they are not getting good services, because some people are pinching here and there, or they are not running the offices properly, then the constitutional project is failing. Because the Constitution was not reimagined so that so and so can be in office. That was not the purpose, because for some people that is the reason. That's why you saw some of them say at some point that because more years left, we don't need a new constitution. Because for them, the constitutional reimagination was a means towards ascending in political office, isn't it? Grabbing power. There are others who looked at the document and said, as it is formulated, this can make me president. I think if I do my mathematics, it will mathematic. Through this formulation. The others who looked at it and said, I think I can ascend to this position with this formulation or not. But for the ordinary Kenyan, be that as it may, whether you are going to be a judge, whether you're going to be the president, whether you're going to be a minister, whether you're going to be an MP, whether you're going to be appointed the chairperson or a member of a constitutional commission, at the end of the day, they want their children to have 3, and as we like saying, square meals. They want their children to go to good schools and be taught properly, not only the school. They actually don't want their children to go to hospital because there is good preventive health mechanisms, isn't it? But if they have to go to hospital, they want to get the best services. That is actually just what matters to Kenyans. So if we want to answer ourselves whether we are succeeding as a judiciary or not, as an important arm of the state or not, let's ask ourselves, are the lives of Kenyans better today than how they were in 2010? And so in also answering what we do to improve that 50% perception mark, the other ingredient is how in our work as this institution of the judiciary are we putting effort into ensuring the material benefits that Kenyans imagined for themselves in 2010 have come to be. The bigger picture. as we are going to see. So the social cultural aspects, the utu, the dignity, utu. And utu begins with ourselves, isn't it? It's a very individual utu. So you have to ask ourselves, if I don't have utu, will my pronouncements have utu? Will my interpretation, my synthesis of what is provided by the different sides that appear before you, if dignity is not a guardrail, utu, is that bigger picture going to succeed or not? And then administratively or programmatically, we have the projects that we churn out to help us guide our work. So I think after looking through this important document, I think it captures a lot of what are the impediments and the prognosis of how we can deal with some of these challenges. And so we could ask ourselves also, 7 months, because I think this document was launched in March of this year, this strategic guide. How far are we? There are short-term goals, medium-term, and long-term. Maybe by tomorrow we should ask ourselves, how far are we in implementing this strategic guide as a project towards making sure Kenyans are dignified. And so as I finalize and extrapolate the bigger picture, when people ask me, what did Kenyans want of the Constitution, I normally direct them to the preamble. I know most people ignore the preamble, isn't it? They think it's some poetic language. Dibaj. But I think there's good precedent from, I don't know whether it's Justice Sachs, about the preamble of the South African Constitution, that the preamble is not just a throat-clearing page in our Constitution, but it is part and parcel of the Constitution. And so in whatever we are looking at, we must go back and ask ourselves, these different paragraphs of the preamble, because are the ones that really surmise and very aphoristically capture the picture that Kenyans had, and more so, the paragraph I flagged out, the commitment to nurturing the well-being of Kenyans. The portrait, something you haven't touched right now, until now. Chapter 5. How do you look at what does a Kenyan want? How can you tell this is a Kenyan? Apart from, for those of you who are active in social media and you see what Nigerians think of Kenyans, what Tanzanians think of Kenyans, etc., there's a lot of content around that. Some is helpful because sometimes it's other people who really tell you about how they perceive you, isn't it? When you can't see yourselves properly through a mirror, so other people become your mirror. This is how you are. The Tanzanians think we are very loud. We are very aggressive. We don't have manners, isn't it? And we like picking cookies from jars that don't belong to us. I mean, those are things you get when you meet foreigners and they tell you about ourselves. But as ourselves, what is our mirror? What is the Kenyan, and what did a Kenyan think of him or ourselves and into the future? And I think chapter 5 are the antecedents. a healthy Kenyan, a well-educated Kenyan, a Kenyan who is free to move around, a Kenyan who is free to enterprise, a Kenyan who lives in a clean environment, a Kenyan who can access employment, and when he or she is employed, is treated properly, is dignified. And all those rights that are cemented really around Article 19. That the Bill of Rights shall be the center, shall be the pillar of what Kenya really is and who a Kenyan is. So that's a portrait of the Kenyan. That we are always supposed to ensure that when you take a selfie, it portrays that. And the vehicle is the entirety because of the Constitution. Because the institutions that are created, including ours, the devolved governments, the executive, etc., those are means, those are the institutions, and I think we talked about that. And what is the destination? The destination is unfinished business, and I propose it to be unfinished business, even of this chapter. And why? Because quality has no end. This is a qualitative mission. I remember when the Commission on the Implementation of the Constitution dissolved, there were many questions, especially from the media. So what will happen to the implementation of the Constitution, because now we don't have the CIC? Or sometimes, when will we finish implementing the Constitution? And so when you tell them that we will never finish or finalize implementing the Constitution, because this is a going concern. If last year, for instance, we had 5 cases of judges who misconducted themselves and were removed from offices, in the future, we have 2, and into the future, we're actually now dealing with none, but how the quality of service is increasing, that becomes the yardstick. And so, ladies and gentlemen, we are dealing with a document, we are dealing with a chapter that Kenyans created to remain as unfinished business, because they expect a qualitative improvement of the implementation of the document, implementation of the chapter. I saw yesterday ESCC releasing their results, I think, for the 2024-2025. We were able to recover this amount, which is good, and we congratulate them compared to the previous year. But I think the other question now we have to push ourselves and ask and call and convict and challenge ourselves is in asking ourselves, if we recover 3.4 billion, is that what is optimal in a year? Because you could have recovered 3.4 but lost 200, isn't it? But what I'm trying to say is that we must always challenge ourselves. Not, yes, celebrate the small victories that we have, but always ask ourselves, is what we have delivered today the optimal of what we can deliver and present to Kenyans in serving them and ensuring that their dignity is preserved and scaled to higher levels. Finally, from Bertolt Brecht, in his poem, The War Primer, we must ask ourselves, because this is internalized, it's beyond the law, the legislation, but in us as human beings, and especially from the positions we serve, are we those who are full in our stomach but speak to those who don't have of the good days ahead? Thank you very much, ladies and gentlemen.
Thank you, Mr. Mukangi. Let us give him another round of applause. Let's give him an Obama until he sits down. Thank you so much. Thank you so much. You have taken us through this historical lane in the constitutional making, and in particular the enactment of Chapter 6 of the Constitution. I'm sure we have quite a number of comments and questions to pose. We are squeezed with time. When you look at time, it's now 11, but I think it's because we started a bit late. So is Chapter 6 unfinished business, a going concern, or a work in progress? Perhaps because I am the chair of this session, allow me to take the first question, which is that as we try to implement this or enforce the Chapter 6 of the Constitution, you realize that the bodies or entities that is charged with the implementation sometimes face a lot of challenges. And I think part of the challenges that I have personally seen is actually created by the Constitution itself. And I have in mind, because you are one of the drafters who drafted this Constitution, what did you have in mind when you drafted Article 99? That before the EACC stops or bars someone from contesting a leadership position, he should exhaust all avenues of appeals, including review. Well, we all know that once somebody has been found guilty of perhaps corruption or stealing public funds, what we will need to do is simply to file as many appeals or reviews as possible and just simply pack them in court with no end in sight. And so this kind of ties the hands of those bodies that are required to implement. So what really informed the drafters in coming up with this article? Or it was also an article that was sneaked in, because you have talked of how the WACO draft and the harmonized draft came into force. So that is my question. But thank you so much for really comforting us, despite the fact that we are still coming to a reality, to the scorecard that we were given yesterday. But you have told us that, as the book of Luke 12:48 says, to those who much is expected, or much is given, much is expected. So that's a bit comforting to us. Thank you so much. Now, I think I will invite four questions, or because of time. Let me, yes, Chucky there. Caris in the middle. Do we have? Okay. Judge and I. So let's take those. Chucky, come on.
All right. Thank you very much, Bobby. It's nice to see that you've really have so much passion, even so many years after looking into this constitution. So my question is this, that you have told us about what Kenyans reimagined the Constitution of Kenya, what Ugandans, Nigerians imagine Kenyans to be. But being a member of the committee of experts and having come up with this constitution, what do you imagine the judiciary to be? Scorecard.
Sorry, I think yes, please
Yes.
go again, Judge Kamau.
The last one?
Yes.
The last part, Mkangi?
Yes.
Right. So what's your scorecard on the Kenyan judiciary? Because you were there, so have we done anything that you expected us to do, or have we fallen short of what we should have done? Thanks so much.
All right. Judge Karaoke.
Thank you. Let me also comment on the issue of integrity as presented. Thank you very much. I have really felt you, the presenter, but I would like to comment and hear your response. First, I have a point here where it is stated that, in essence, Chapter 6 was the constitutional moral compass. Its unfinished business is Kenya's ongoing struggle to align political practice with constitutional ideas of integrity and accountability. I don't know whether you agree with that statement, but I'll hear your comment. And then there is also a suggestion of what is indicated as a pathways for reimagination. Just briefly, the 5-point very fast, the chair of the session. It is indicated that maybe Kenya should enact laws that clearly define integrity threshold for the public office, empower EACC and IEBC with autonomy and resources to enforce Chapter 6 without political interference, judicial consistency, develop jurisprudence that prioritizes constitutional values over technicalities, civic pressure strengthens citizens' oversight and activism to demand accountability, and finally, cultural shift, promote integrity as a political value through education, civic education, and leadership training. You can comment on that. Take into account of the political ecosystem in Kenya today, the situations of our, especially parliament, which is supposed to lead in legislation. And finally, whom do you think can be able to initiate this?
Thank you.
Starting point.
Thank you. Thank you, Judge. And Judge Andai.
Thank you, Bobby, for the great manner in which you have delivered this. I'm feeling that there is the unfinished business in the Constitution, or the path that we need to embark on or look at is the manner in which to entrench ethics among Kenyans. It was a bit narrow to think that it's only leaders who would have, been required to follow these ethical pathways as provided for in the Constitution, because these things begin at very early stages of development. And I do not see in the Constitution a provision that, they have to be infused in people from an early age, so that when you look at it, people try their best. I mean, you are not going to get ethical leaders through interviews, through elections, through appointments, and someone who has been unethical or does not match up to that chapter, just for the reason that they have been given a position, then they are going to change. We've seen it from 2010. We've seen vetting. We've seen all manner of ways to ensure that we have ethical leaders in leaders, but again, we still fall short of that of those requirements. So I'm thinking probably going forward, we should now focus on how do we ensure that every Kenyan at the very early stage, probably through the education system, is an ethical person, rather than focusing on individuals who have already kind of their own mannerisms in the way of doing their work. Thank you.
Thank you. In other words, how do we inculcate good virtues and Chapter 6 in the hearts of everybody, every Kenyan, young and old? Bob, the floor is yours.
Thank you very much. ladies and gentlemen, for your responses, your comments, and the questions. Session Chair, 99.3. When you look at the previous drafts, it was there. But also we laid emphasis on it. And it was, I recall it was an issue we really talked about and debated, and around the questions of which, in a way, your institution, the institution has come to sort of give Kenyans a direction around how intermittently we deal with persons, and especially in high offices who have been put within the prosecution mechanisms to find whether they are of fault or not, through the Public Officers Ethics Act and the suspensions. And now, as we know, where, and especially we've seen our governors, they are barred from accessing office, which means not the physical office only, but exercising the mandate of the office or undertaking the responsibilities. And so it gives certain direction in that dilemma that also we had. But part of the dilemma and challenge was not in the principle itself, because the principle actually captures or is aided by principles of natural justice, fair trial. You are of fault eventually and ultimately when all the mechanisms that have been provided to find fault or no fault in you have been exercised. So the question we were asking ourselves at that time was, what if that process takes 10 years? Because we're also dealing with the circumstances that were alive to that nature. And there are those who felt, no, you mentioned step aside, you know, and you're disqualified thereof. And especially, you know, that is very much what the civil society, to the extremity of it, feels that should happen. But at the end of the day, we were guided by also the Bill of Rights, Chapter 4, and the rules of natural justice. So the challenge now, and it's what we are facing now, how do we expedite cases where somebody is mentioned, and we make sure that they do not use this, as you said, you pack different challenges as to what you're accused of in court, so that delays, because that's the loop. In fact, that's the thing these personalities take advantage of. They know this is going to last a lifetime, so just go to court and put all manner of roadblocks, and after 10 years, when this is finally decided, I'll have finished roofing my house back home, and I'll have my 4 SUVs and my private plane, and now you can deal with that after that. So I think that's we left the principle as is, that truly if mechanisms are provided to ensure that you get justice, those should also be accorded to every Kenyan. But now the challenge was that happens, but we know that takes time. So at the end of the day, it's thrown back to us as the justice sector, and something that I know we are trying to deal with even within our strategic guide. How do we expedite cases? How do we ensure, like was mentioned, I think later, technicalities are not used to excuse fault or guilt? And maybe I may combine this answer with the question that came from Justice Kamau around the scorecard. For me, I think it's a mixed bag. Maybe I fall amongst those Kenyans who, gave it 50%. In chapter 6, I think we've sort of given good direction so far. And that's why we, as I said earlier, we have personalities in this country who are prohibited from holding public office into the future because of the Constitution, not because the judiciary or a particular judge or judges hate that personality, but because Kenyans have said it in the Constitution. So I think in that, and probably that's what is also adding to the level of stakes at hand when these cases come about. And probably that's what also propels, again, in people trying to use the very bad behavior, the bad manners, to accumulate more of what could be a war chest, so that when those cases are presented against those personalities, they can use the war chest. And we know what the war chest is: money, influence, power, etc., to make sure those ends are defeated. But in terms of what has come from the judiciary, right from the Matemu case, I think that's 2013, to now Kenyans knowing and that if you are mentioned, if you are governor, step aside until your matter is reasoned to the end. I think the 50% where we might be losing is, like I said, and again, I don't know whether you are to blame forthrightly or directly. It's in, I think, the speed of the cases, what everyone has been saying. How do we ensure this, we deal with these matters and these cases expeditiously, and also in a way that does not invite conjecture? As I said, Kenyans are watching. They pick patterns, and they talk about those patterns, and you cannot prevent them from. And some of those patterns are actually real, whether they confirm what the perception is or not. They unfortunately affect you as an institution or you as the official when it comes out and cannot be clearly explained why a certain decision was taken. So for me, I think the 50% that is to be recovered actually is around how we deal with these cases, and when we pronounce them as the way we must pronounce them, because that is what is before you, how do we explain to Kenyans? How is it communicated to Kenyans that this is actually the law, that the institution has made the decision pretty much premised on what the law provides? So there is that. But in terms of chapter 6, I think there's good direction, but more could be done. Political ideals, the struggle for judicial and the political ecosystem. I think this again is a continuous challenge and process that we must deal with and deal with quite effectively and properly. We ask ourselves why is it that Kenyans eventually come to perceive, if I may go directly and narrow the question, why do they perceive, especially of the judiciary at some aspects of times, that there is political interference? Internally, if you take a selfie and ask yourselves of what comes out. Why does that happen? Is it because a politician said it and then it's a chorus, or is it a reality? Why is that perception? And especially when you look at how Kenyans designed the institution of the judiciary right now, why the JSC is as is. People say, oh, we borrowed the system from Americans, etc. But when you tell them, and they now see especially how judges are appointed in say, the US, justices are appointed there and here, where the JSC, and we know there's been political fights around this, but where the JSC is the alpha and omega when it comes to who serves within this institution. Again, coming from Kenyans and from the experience of Kenyans seeing when the executive or the politicians have a hand in meddling with this institution, that's how we lose this institution. And that's why they went to this very extreme, novel way of saying, we don't want any politicians in these mechanisms. There is a question of eventually, because when you look at the appointment of the JSC and how many personalities are eventually appointed by the executive, there is a question of whether that eventually plays out in the decisions that the JSC makes. Again, mixed with, as I said, the difficulty from a societal level of judging or interpreting what is corruption, misuse of office, a leader with bad dignity, not dignifying himself or herself and Kenyans. And whether it's Mtuwetu or not, or, corruption, bad leadership is other people. So there's that challenge also, and that will always, I think, come out. But I think if the commitment and conviction is around making decisions which, after a certain period, a clear pattern can be birthed, and where Kenyans can see, in as much as this institution at times is making decisions that we are not happy with, they are making them in accordance with the law and the Constitution. The comments and bad perceptions will always be there. But Kenyans will comment because they designed you to be strictly independent. The Judicial Fund, the JSC, even pronouncing that you are independent, beyond just, and then they saying this institution is independent, and then creating specific measures to ensure that you're independent. So eventually when they see that, unfortunately, the fight is not around breathing life to those provisions, amplifying those provisions that ensure you are an independent entity, but going back to conducting ourselves as if it's pre-2010, I think that challenge will always be there. So I think the onus upon us is to ensure that we function really, pretty much strictly in a way that Kenyans commanded us, that we have put these guardrails and we have ring-fenced you this way and given you these provisions to protect you. So please use those, don't use others. And they did that specifically so that there is no overlap and the creation of the perception. So it goes on being a long-term project, continuous project, a challenge. But I think it's, as I said, it's upon us now to protect that independence and to ensure that that perception of political interference is not easily or quickly legible amongst Kenyans, if at all it should be. Finally, yes, I agree. And that's why I also mentioned that part of the challenge is societal. It is cultural. Kitu kidogo, kakitu. Nothing can be done for free. And that is okay. You do work, you're paid. But we know that other free of Kenya, Mtuwetu syndrome. So I agree that even as a society, and I think the ESEC and the Attendant Act, there's that provision and mandate of ensuring that there is education, and it's also in the strategic guide, how to add impetus upon that. More talks around that, about how leaders should conduct themselves. How do they feel dignified? Do they feel dignified when we post pictures of our Range Rovers? You know, I mean, there's some things, it's common sense. You know, the other thing is it's also common sense. In fact, sometimes I feel we have done, it's as if with this issue of good manners in office and institutions, as Kenyans, we have been doing a lot of dancing around, tap dancing around the issue. Because tabia mbaya and tabia mbaya, wizi ni wizi, isn't it?
Yes.
Yeah? Tabia mbaya and tabia mbaya, wizi ni wizi. So at times we probably even complicate it more by all this vocabulary, all these language games around things which should be commonsensical, should be obvious, and we complicate them to the level where now we even lose the entire project.
Thank you.
So I think
Thank
Kenyans
you.
want more than the words.
Thank you so much,
more
Bob.
action. Thank you very much.
Thank you.
Mrs.
I know you had so much unfinished things to say, but because of time, there is another presentation immediately after tea, so we do not want to really eat into it. So let's give our speaker another round of applause for a job well done. I know many of us still have some comments or other questions, but I think we can engage as we take our tea. Because of time, I am instructed that we will only take 20 minutes for tea, then we get back so that we finish.
that our presenter is the Deputy Director of Ethics and Anti-Corruption Commission. He's an advocate of the High Court of Kenya. He has a degree, a bachelor's degree in law. He has a master's degree in law, both from University of Nairobi. He's also a postgraduate of Kenya School of Law. He has over 20 years experience, and he's a researcher of many years in matters related to corruption. So if Josephine Mungare is not here, I'll call the presenter so that we can start. Josephine Mungare, once again. She was supposed to tell us something before we start, but because I can't see her, I think so. So I'll invite the presenter, Patrick Owini. Can you give him a clap as he comes? You don't want to go there.
I can go there.
Yes,
It's okay.
that
Thank
is
you.
a better place.
Thank you. This to just scroll it forward and backward. Okay, yes, okay, yes. Okay. Thank you. It's already there. Okay. Honorable judges, all protocol observed. Good afternoon to you. This afternoon, I'll take you. My name is Patrick Owini, as indicated. I'm a Deputy Director, Ethics, Compliance, and the Ethics and Anti-Corruption Commission. So this afternoon, I'll take you through the emerging jurisprudence and its impact on the implementation of ethics and integrity requirements. I do not purport to have all the jurisprudence, but because majorly this lies with you in terms of the judgments, in terms of the pronouncements you make. But I will attempt just to highlight some of those that perhaps we think have helped in the fight against corruption and also in the improvement of Chapter 6. The list is not exhaustive, so perhaps if some are quoted, this is just a disclaimer. If some are quoted, perhaps do not say that there are these ones, there are these other authorities perhaps which are also there and are not indicated here. So the list is not exhaustive. This afternoon, I'll just take you through the foundation of ethics and integrity. Again, these are just generally the laws outlined related to the laws that are there. Then the mandate of the commission, we'll just remind ourselves at times there's also a lot of misunderstanding about the commission. So it's just good to know what does the commission do so that when you judge the commission, you are also able to know what it does. At times people are saying, no, you have not prosecuted the big fish, the small fish. And we tell them, no, the commission does not have prosecutorial powers, but it investigates and forwards the file to DPP. Then just to also resonate the fight against corruption and the human rights, to resonate it with the theme of this conference, we'll just looked briefly at how corruption undermines human rights. Then in terms of just setting the ground for ethics, integrity, and leadership, emerging jurisprudence will look at it. What are some of the milestones that have been made? Challenges and the way forward. And essentially, as Anti-Corruption Commission, we do not have all the answers. And the fight is not for the commission alone. It is for it's for me, it's for you, and it's for every Kenyan. So again, we would be pleased to get some suggestions, feedback on how to do it better. We do not have all the answers. In terms of legislative framework, we have just highlighted some few, and we have just started with the supreme law, the Constitution. It gives the foundation in the fight against corruption, and particularly you look at Article 10, Chapter 6, which is the core in terms of leadership and integrity. Kenya is also not an isolated country. We belong to the global community, and for that reason also we have the United Nations Convention Against Corruption, UNCAC, which was ratified or which was passed in 2003. Indeed, Kenya was the first country to ratify and sign this convention. The then minister, Kirayutu Murungi, said that for Kenya, corruption was a matter of life and death, and we could not wait anymore. So this was done in 2003. And we have the African Union Convention for Preventing and Combating Corruption. Again, these are key international convention that Kenya is a party to, or Kenya has ratified and signed. And indeed, the two also do apply in Kenya by virtue of Article 2.5 and 2.6 of the Constitution. Then we have the Ethics and Anti-Corruption Commission Act. Again, that is the primary legislation that creates the commission and also teases out some functions for the commission. We have the Leadership and Integrity Act. That is the law that has been also passed pursuant to Article 80 of the Constitution for purposes of implementing Chapter 6. Then we have the Anti-Bribery Act, again, of 2016. That's again the law that deals with the issues of bribery. It cuts across bribery in the public and private sector. We have the new kid in the block, Conflict of Interest Act, number 11 of 2025, that was assented to on 30th July this year and commenced on the 19th of August. Again, it did repeal the Public Officer Ethics Act, save for the transition clauses, and it provides generally substantively in terms of management of conflict of interest and regulation and management of declaration of income, assets, and liabilities. This year being a declaration year for the biannual, this law applies. We had, as a commission, issued out notices. The JSC is a responsible commission for management of declarations of income, assets, and liabilities. So it started from the 1st of December, the last date being the 31st of December. The new law has criminalized almost all. Initially in the Leadership and Integrity Act, the conflict of interest was majorly prohibitions, but it has actually penalized quite a number of areas or infractions. Then we have the Anti-Corruption and Economic Crimes Act of 2003. I think that has been also the major law in terms of fight against corruption. We have Proceeds of Crimes and Anti-Money Laundering Act. Again, this act was amended, and it gave the Commission the mandate to look at the proceeds or to deal with the proceeds of crime. Other laws among this list is we have the Public Service Values and Principles Act, essentially meant to strengthen Article 232. We have the Public Service Value, we have the sessional paper number 2 of 2018, National Ethics and Anti-Corruption Policy. Again, it lays out the policy framework for the fight against corruption in the country. And then we have the sessional paper number 8 of 2013 on the national values and principles of governance. Again, it is a key policy paper in terms of values that are there. The list is not exhaustive, but these are the major ones. We have the Public Procurement and Disposal Act, which the Commission also implements. So the list is not exhaustive, but those are just some highlights that will form the basis of our discussion this afternoon. Just to highlight quickly on the mandate of the Ethics and Anti-Corruption Commission, generally it's I can say it's a four-pronged mandate in terms of law enforcement. And in terms of law enforcement, it is mandated to investigate all cases of corruption, economic crimes, and ethical violations, and make recommendations to DPP, that is under Section 35 of Anti-Corruption and Economic Crimes Act, and Section 43 of the Leadership and Integrity Act. It has also an independent or standalone mandate to institute proceedings in court for freezing, preservation, and recovery of irregularly or illegally or corruptly acquired assets. In terms of asset recovery, I think this is one area that the Commission has done well, and this is one area also that the judiciary, the anti-corruption courts have done well in terms of the authorities that have been churned out. Indeed, among the authorities churned out by our courts are actually being used in other jurisdictions like even the UK. So we have groundbreaking authorities in this area, and I must commend the judiciary for that. In terms of prevention, again, this is a key mandate given to the Commission, and as you are aware, this is from the old public health adage that prevention is better than cure. And in this respect, the major area of prevention is what we are having, like what we undertake, the Commission undertakes in this area is corruption risk assessments and examinations of systems and procedures. Corruption risk assessment simply diagnoses a problem, is a quick diagnosis of a problem, and then making some quick recommendations. And then examinations of systems is more detailed. You will look at the systems, identify the loopholes, and then make recommendations on how to seal those corruption loopholes. I think the judiciary also have benefited from this. I think when we started yesterday, there's a colleague that I think took you through this. But I think this is the area in terms of systems examination that was done in terms of the projects the judiciary is undertaking, and the other was in terms of registries. And I think we were able to walk you through what is there, some of the challenges, some of the loopholes, and how to seal those loopholes. Again, the Commission is mandated to do public education and awareness. This is another role given. As you will know, corruption also thrives in ignorance. When people do not know, perhaps what is required, the service charters are not there, and information is not there, that gives corruption room to thrive in. Then the other mandate, or I would call this the fourth, is the promotion of ethical standards and practices. And this involves quite a number of areas, some under the Leadership and Integrity Act, some under the Conflict of Interest Act. And essentially, this involves the specific leadership codes that state officers are required to ascribe to, and also issues to do with Chapter 6 violations of the codes and vetting or integrity vetting in terms of Chapter 6. So essentially, those are the mandate of the Commission. It does not have prosecutorial powers. There has been a debate, should it have or should it not have? Perhaps that is a debate perhaps we will not deal with now. Perhaps we may remind ourselves of some of these terminologies. We hear them every day, and it's good just for us to remind ourselves when we talk of ethics, integrity, and leadership. These are concepts perhaps that we hear on a day-to-day basis, and we also apply them on a day-to-day basis. So generally, in terms of ethics, it's a set of principles of right conduct or a system of moral principles. And it's generally a principle of conduct governing an individual or group individual, you can have those a code of conduct. I'm sure for the judiciary, you have the judicial code of conduct that all members are meant to ascribe to, all judicial officers, and the judges are supposed to apply. It also helps as a guiding philosophy. It tells you what ought to be done, what need not to be done, and generally it will act as a moral compass. When you are using it, you are able, it helps you in your decision making from time to time. So ethics, therefore, helps a lot in terms of guiding our conduct as individuals, as professionals, when we are undertaking our duties and responsibilities. In terms of integrity, again, it's not new. It's a word that we hear from time to time. And indeed, it's a word, or it's an aspect that Kenyans in 2010 decided that it was in short supply and we needed to have it in full, have it properly, and practice it. Again, whether we have lived as a society, we have lived as per what is required, again, think that one I leave to each one of us to judge. But generally, in terms of definition, the Black Laws Dictionary defines it as soundness of moral principles and character, as shown by one person dealing with others in making and performance of contracts, and fidelity and honesty in the discharge of trust. And the term is also synonymous with probity, honesty, and uprightness. Generally, it is defined in terms of dealings one is having with the other. How do you conduct yourself? How do you carry yourself? Can your word be a check? I can go to the bank, your word, take it to bank, and whatever you have said is final. It also defined as purity, uprightness, purity, sincerity, honesty. So essentially, all those describe or attempt to describe what integrity is. Others have described it as simply doing something good or doing the right thing when nobody watches at you. Perhaps it could be the creator just watching at you, but no one else watches at you. So essentially, it's a big challenge, in the country that we are dealing with. As I was going through this presentation, I just got this story of the empty pot. And this was a king that was felt he didn't have a child and he wanted a successor. So he got a number of children, around 100 children, and he told them that he gave them a seed. So each child he gave a seed and he said, you go plant this seed, and after 1 year, I'll want beautiful flowers that would have come from this seed. So he gave all of them. So one of the children planted this seed, and nothing came out of it. The child was very frustrated. So at the end of the year, when they were reporting back to the king, everybody had beautiful flowers they were taking now to the king. The only one child out of the 100 who did not have the flower was really frustrated. The king told him, relax, don't worry. So he looked around and looked at the 99, looked at the beautiful flowers, but he only said, the king responded that it's only one person that has actually told me or brought me the truth. The seed that I gave you were boiled. So there was no way they would be able to actually grow or even sprout. These were dead seeds. So if you did perhaps come with a flower here, then you have done something else. You have not planted the seed that I gave you, because those ones were boiled and they could not get flowers out of them. So he had the throne, he took over the throne out of the honesty. So that's just a simple example of integrity. So we need integrity is actually manifested in also very small things. We do not need to have very big things to manifest integrity. terms of leadership is again a key word in terms of management and in terms of any organization. And leadership is the ability to influence, guide, motivate a group of individuals towards a desired goal. You actually need to rally all these individuals, and as you rally them, there are quite a number of things you may need to do. You may need to influence and guide or give guidance. You also need to help them achieve the goal, because even as an organization, you have a goal to achieve. So you rally the leader who has the vision, rallies the other members so that they are able to achieve the goal. And as you rally them, there are other things you need to do. As a team player, you need to motivate and also empower. So a leader should be able also to motivate and empower. A leader should not be selfish. Having looked at that in terms of integrity, ethics, I think the theme of this conference speaks to human rights. And it would be unfair for me also to leave the issue of corruption and human rights. What is the linkage between corruption and human rights? And you'll notice that corruption generally, or bad leadership generally, is linked to corruption, which undermines human rights and dignity. And this is done in various ways. One of them is diverting funds from essential services. As a country, you know what we are going through in terms of healthcare, and you will see areas like health, if it is not well managed, resources that are there are actually wasted. People end up suffering, people end up dying. Education equally is demanding in terms of resources. We have even the new system of education that requires a lot of resources to be placed there. If not well handled, you are seeing the situations which we are undergoing. And again, that undermines human rights. Issue of housing is key. The water and sanitation and even food. These are fundamental rights that again, corruption can easily undermine in terms of resources that are there, in terms of implementation of these rights. Again, in terms of the justice sector, corruption again can distort justice systems in terms of fair trials and due processes. Again, if not checked, it would actually undermine human rights and dignity. Again, in terms of corruption, if not checked, in terms of eroding the rule of law, people would want to do the shortcuts, and in the process, the rule of law is also undermined. It ultimately enables or leaves citizens vulnerable, and essentially they have nowhere to go to. So this again denies them the right to live a good and decent life. So essentially, corruption, leadership, and human rights go hand in hand. They are interrelated, and one affects the other. Bad leadership, bad governance, actually has an impact on human rights and corruption. So I think it's good to just take note of that. Some issues that we may need to ponder about on the issue of ethics and leadership. I decided just to come with some questions that may help us just to reflect on the same. Is leadership or public appointment in Kenya a personal entitlement that can be accorded to certain individuals, even if they face high gravity cases or serious cases? 2, will there be any harm in recusing some of the individuals in these appointments and consider them later if they are cleared through due process? Can we have to wait in terms of some of the appointments? What should be the standard of proof in unethical matters? Again, these are some of the questions that we grapple with when we are dealing with issues of ethics. You have seen somebody who is perhaps just discourteous. Do you need to prove that beyond reasonable doubt, or that is something that can be dealt with summarily? It's unethical. Why are the standards of ethics and integrity for public officers continuously lowered, while in private space, perhaps like in our homes, in our families, the bar stands high. Would one hire a guard, a gardener, or a house help being investigated or charged with a criminal offense? Perhaps I may not have the answer, but I thought these are some of the questions as we undergo these discussions we can think about, just to help us reflect on the issues of ethics and leadership. So in terms of chapter 6, again, on leadership, the Constitution 2010 offers or gives us a paradigm shift in terms of the public trust, what I may call the public trust doctrine, in that we as leaders, we are actually given the offices. The sovereignty belongs to the people, but again, 50 million plus cannot be in all these offices. So essentially, we have been given the privilege to serve in those offices, and therefore, we are there as trustees, and therefore the issue of public trust is paramount and is overriding. In terms of Chapter 6, the Public Trust Doctrine from the Constitution 2010, it sought to transform Kenya from a culture of power to rule and to a culture of public trust and servant leadership. And I think that is the running thread in Chapter 6. If you look at Article 73, it outlines the Public Trust Doctrine, which is authority to be used to serve the people, not individuals. So our authority is for service. Again, it sets out the key principles in terms of selection on basis of personal integrity and competence and suitability. Issues on objectivity and impartiality is a key principle in decision making, whether we are doing a policy, interpreting the law, or taking any administrative measures. We need to look into that. The issue of accountability to the public, again, is key. We are there for the people of Kenya, and essentially they want to know what we are doing, and this is expected of us. In terms of emerging jurisprudence, I've attempted to look at various areas, and one in terms of appointment and suitability for public office. So again, this area, the issue of integrity comes in, and it is key. In terms also of the elective positions, what perhaps have we come up with in terms of elective positions? And there are also quite a number of jurisprudence around that area. Then there are the areas on suspension, that is stepping aside by public state officers, charged in court for corruption and economic crimes. Again, that's an area that has also drawn quite good jurisprudence in that area. Then we have also the area on debarment, or persons being barred from holding public office. And this is through conviction. One of the areas under Section 64 of Anti-Corruption and Economic Crimes Act, when one is convicted, part of the punishment will be debarred from holding office for the next 10 years. Anti-Bribery Act, I think Section 18, also has those provisions. Then in terms of impeachment, again, this is an area under Section 75, Article 75, when one has been found not to be proper to hold public office. Then removals by tribunals. Again, this is another area in terms of leadership and integrity that courts also have done quite a lot of work. We have other areas of unbecoming conduct. These are situations where state or public officers, we see them behaving badly. This could be in the assemblies, the National Assembly, it could be in the county assemblies. Again, I think in that area, there has also been pronouncements that have helped us to shape that particular area. We have dual or double employment. or other gainful employment while full-time public or state officers. Again, these are an area that is there. You find that public officer or a state officer, majorly with public officers, they are employed. You find that they are employed even in two areas. One will be employed in a parastatal, is earning something from a parastatal. Again, you may find employed even in the judiciary. So you'll find somebody, you wonder at what time does he get the time to work full-time in the two institutions. It may look a joke, but it is happening. And we have been able to get quite a number, recover, take some disciplinary action. Some have also been taken to court. So that's the extent it has gone. Then we have fraudulent acquisition of public property, the use of forged academic or falsified academic certificates and professional certificates to obtain employment in public service. This has been very, very common. You remember when the head of public service did issue a circular that all the certificates for public officials be verified. So out of this process, about almost 2,000 so far certificates were found to be forged. So essentially, this is a big, big area that as a country we need to rethink because cases where we are getting is that some up to the level of PhD have been forged. Some are lecturers in universities, have either forged the Form 4 certificate, the degree certificate, or the master's certificate. So it's a big, big challenge that we are having as a country. We need just to rethink where did the rain start beating us on this area. So it's an area we have been grappling with in quite a number of institutions. Some have taken administrative action and gone home. Some we have investigated and actually taken to court. One of the charges that is being recommended is, the DPP has been recommending, is fraudulent acquisition of public property, because the argument is that from the word go or ab initio, you are not supposed to get that employment. So the fact that you used that forged certificate, essentially you are not entitled, and therefore you are required to even pay the entire amount. Some come up with the defense that yes, we worked. I worked for that period. So why do you want to recover it? But I think also the courts have actually come up with very, very good judgments around that area. So quite a number of cases we have been having. Many of them we are seeing they have been exploring the plea bargain agreement in terms of refunding what is there and also in terms of sentencing. So these were quite a number of cases, I would say, have been concluded through plea bargain agreement in this area. The Anti-Corruption Court have done very, very well around this area. And it's also sending a very strong message to would be those may be intending to forge the certificates. So it's an area that what we are even getting at the moment is that despite us taking people to court, in some of the jobs being applied, people are still even attempting to use those forged certificates. So Kenyans can also be daring. One of the cases we did, I think it was the first one, and somebody had to pay. This was a person that forged the degree certificate and even master certificate, and was a senior head of the HR in one of the institutions, public institutions. And she paid back, I think if it was added with interest, she paid back 13 million out of the whole amount that was earned. So there's good jurisprudence arising from that. In terms of appointments, the area of appointments, we have the Mumo Matemu and Trusted Society of Human Rights. I think these are a key area or a key pronouncement that has helped in terms of shaping Chapter 6 in terms of unresolved integrity issues. And I think the pronouncement, the fact that it went even to the Court of Appeal, but the pronouncement of the principles came out very well, that indeed Chapter 6 is not just superfluous or ornamental or lofty aspirations, but it needs to have a substantive bite. The question will be, how should it have this substantive bite. That has been what we have also been grappling with. That's what also we are looking upon the judiciary just to help shape it more. One of the arguments that has been placed is that the Leadership and Integrity Act was not foolproof. It was weak. And again, at times, no law may be foolproof. I think the Commission on Implementation of the Constitution challenged even this in court. The court did find that it was constitutional. Subsequently, various attempts also have been made just to strengthen it, though it has not fully happened. It's work in progress. The Parliament is normally very, very keen in amendment of anti-corruption laws or any laws dealing with anti-corruption. They would actually be very, very keen. All their antennas will be up. They'll want to look at each and every provision. So at times you have the omnibus provision, you will not get it. Perhaps you have the one-by-one amendments, you may be lucky to get some. So to us, this has been a key groundbreaking pronouncement in terms of enforcement of Chapter 6. The second one is in terms of Gikenyi versus Mwaura and 20 others. These are a recent also decision, and it helps in terms of appointment. This was the appointment of somebody appointed to the board chair of one of the parastatals, and the question was that him and others were facing anti-corruption cases in court, and indeed the petitioners challenged this. They questioned in terms of the place or in the chair, the board that he was meant to chair would be unfit to chair that particular board, and I think the court did quash the appointment due to pending corruption charges. I think it could be pending somewhere in appeal, but at least that was a bold step, and it went a long way in terms of enforcement or implementation of Chapter 6. Again, Kia Mutata Koti versus the Attorney General, I think he has also very many petitions he has done in terms of public interest litigation that has also helped in terms of appointment, and that to us is very important in terms of shaping Chapter 6. Again, this other one was Benson Ridho Mureithi versus J. Wakungu and two others. I know it went up to the Court of Appeal, but the principles therein, I think, were very important, because the argument was that the person being appointed as the chair had many criminal cases pending, and therefore, on that basis, he was unfit to hold public office. And to us, those principles were very, very good. Those was a bold pronouncement in terms of a promotion of Chapter 6. The other aspect, so apart from public appointments, the second limb in terms of Chapter 6 has been in terms of elections to public office. And this is one area, again, that we have a big challenge, because balancing Article 38, the political rights, and again the democracy, is a very delicate balance. The people have to decide, and again, in terms of Chapter 6 or in terms of leadership and integrity, again, the law is here to regulate. And I think the first case in this area was the one on International Center for Policy and Conflict and 5 others versus the Attorney General. I think this is where we had the current president, in terms of the ICC cases that were there. Again, in that pronouncement, the court did not make a strong deliberation in terms of Chapter 6, but it was left to the issue of the right to fair hearing, I think, came in, and it was also left to other bodies to deal with this issue. So this was actually the beginning, again, in terms of challenging issues on electoral process. So again, this is an authority that is critical in terms of one's looking at the foundation on elective positions and the issue of leadership and integrity. And I think many authorities or many similar cases, this authority was used in terms of those seeking election positions and where they had issues. Again, the other one was just on the issue of the same International Center for Policy and Conflict and issues on ethics and anti-corruption commission. And again, this was the question whether those seeking elections, who has the mandate? Is it IBC? Is it EACC? And again, I think the court, in trying to redefine the mandate, did indicate that both institutions have the mandate in terms of looking at issues of integrity, looking at issues of qualifications. So I think to me that is a key pronouncement. The other third one around this area was again EACC versus Nelson Kivali, Musyoka, and these were some of the petitions filed by the commission just prior to 2017 elections. And one of the issues were these were people that had forged academic certificates. So the commission wanted just to test the waters and see how perhaps would be the interpretation of the courts. Are we able to bar them from running for political offices? Again, this is one of the cases. It took some time, and the court finally pronounced itself that essentially this was an electoral process, and it ought to have been heard by the Dispute Resolution Committee of the IBC, though it gave room for that the criminal case or the criminal element would actually go on. So again, at that level, it never went far, but the criminal case proceeded, and I think we got a conviction on the use of those forged certificates. One of similar cases also again was the Granton Samboja case. Similar case also on the issue of certificates. Again, a similar judgment was also given in terms of the elective positions. So essentially what we are seeing that in terms of elective positions, there are varying judgments on it. So we are not yet there in terms of elective positions, in terms of enforcement or implementation of Chapter 6. And this is critical because many of those seeking public offices, you find them, there are people with issues. Some may be having cases in court, in as much as also they have the right to the presumption of innocence. Again, there could be issues that touches on integrity. So again, to the public, they are asking, these are persons charged in court. Isn't that sufficient evidence to bar? Again, you are, on this other hand, you have the presumption of innocence, and again, other provisions in the Constitution that we'll look at. The third area in terms of where the courts also have come very strongly in terms of stepping aside, what almost akin to constructive removal doctrine, where they are saying if you have, for public officers, it is easier because once they are charged, the suspension is almost automatic under Section 64(2) of Anti-Corruption and Economic Crimes Act. But for elective or elected state officers, it has been a challenge because in as much as they have been charged with corruption or any other offense, they will still enjoy their positions. And I think the court has helped a lot in this area by actually coming up with the decisions to the effect that in as much as you may not be removed or there are other processes for your removal, but for these particular cases, you may be quarantined or stay out of office for a while because of various reasons. Could be interfering with witnesses and many other things. So these we have seen in quite a number of cases, but 3 cases stand out in terms of Lenol Kulal, versus DPP. Remember, this is one of the cases that was there. I think the other day he was acquitted. The appeal was allowed. But I think the principles that came out at the criminal criminal case at the magistrate's court was critical in terms of stepping aside when the matters are pending. We have the one of Ferdinand Watitu versus Republic. Again, by then he was the Kiambu governor, and I think the same principle applied, and it came out strongly. And then the Mike Sonko, again, the stepping aside doctrine came out strongly in terms of just to show that the fact that, yes, your removal process is provided differently, and it's a lengthy process, but by the mere fact that you have been charged of corruption related to your office, related to functions of your office, it would be improper for you to keep staying in those particular offices. So to us, this is has been a positive jurisprudence in terms of also trying to breathe life and integrity into Chapter 6. The other aspect is in terms of permanent bar to leadership. And one of the cases I think we have, just prior to 2022 elections, there were quite a number of litigation around this area. But one of the things that came out was the impeachment of the then governor, Mike Sonko, by the County Assembly of Nairobi. And I think it went through up to the Supreme Court. And the Supreme Court affirmed that position, that if impeachment is properly done on grounds of misconduct and abuse of office, it constitutes a permanent integrity breach that permanently bars you or bars the individual from holding future state office. So again, this is an area that would say that the pronouncement was clear, was positive in terms of promotion of Chapter 6, in terms of the elective positions. So to us, this is a bold step that came out of the judiciary. Other areas will be the unbecoming conduct by state and public officers. And these are situations where you find maybe it may be a county assembly, majorly the National Assembly, it used to be there, but I think now there's a lot of order, but majorly county assembly. And this is one of the cases where the county assembly, I think they had lost decorum, they fought, and when the commission called upon them just to answer to their conduct, they said that, or they indicated that the assembly is privileged and they are dealing with the Powers and Privileges Act. Therefore, they would be able to deal with their own matters, would not be able to come in. And they quickly rushed to court to stop any letters that we had used to summon or call them to explain the position. And I think when they went to the court, I think the court came strongly, again indicating that they cannot plead immunity in terms of unlawful actions that they were doing. Indeed, they were saying the assembly is not a place for fist fighting. It's for a place for the brains, using the brains and applying your brains properly to make the law. So again, this came out strongly. This ruling was made. They had actually to comply finally. So there was a plus in terms of unbecoming conduct by state officers. Then we have the other area on participation on other gainful employment. This is where we are saying a public officer getting double or several employments and earning from the same public coffers. And we had this case again of Dr. Agnes Wanjiru against the commission. This was a lecturer, full-time lecturer on permanent and pensional basis at Jomo Kenyatta University. And again, she had sought, or she was offered appointment to be a member of the County Public Service Board at Kirinyaga University, which was almost akin to a full-time, again, public service job. So essentially, again, when the commission came in just to question, she rushed to court, and again, the court did make a pronouncement. The petition was dismissed, and the court actually did make a pronouncement that essentially the employment, taking up the other employment at the County Public Service Board when she was on a full-time employment was indeed irregular and unlawful. So again, this was a strong pronouncement, but strong decision that came out in terms of promotion of Chapter 6 on leadership and integrity. So those were some of the highlights that we had in various areas on leadership and integrity. Perhaps having looked, those were just highlights. I did say the list is not exhaustive. There are quite a number of authorities. Indeed, we are trying to come up with just a compendium on all those areas, or those pronouncements that have been made, so that it can be used as a reference material. What we notice is that the jurisprudence in this area has been progressive. However, there are areas of concern or maybe some consideration. And what we are seeing is that there are some gaps in some of the decisions and non-definitive. Some of the decisions are non-definitive. They leave a lot of rooms that even for decision or for implementation, it becomes difficult. So this is one area perhaps that in terms of interpretation, the judiciary may want to look at it in terms of elective positions. In terms of appointive positions, it's not very much problematic because once you have given a recommendation, they may decide either to drop the person or to suspend, but for elective, it is becoming a challenge. Then striking a balance between presumption of innocence and accountability. You want this person, he has been even charged in court, but presumption of innocence is there. But again, you want in terms of accountability. Do we leave this person to continue? Again, that's one area that still I'll think there's room just to check or room for interpretation. Then the standard of proof in ethical matters. Again, this is one area that has been very problematic. Ethical matters, do we need the standard of proof beyond reasonable doubt? Is it on a balance of probability? Or where does it fall? So this, for a long time, even for the public, it has been that for even any ethical matter, it's like you would want to have almost evidence or standards beyond reasonable doubt. So this is one area that has been very problematic. In other jurisdictions, we have the ethics tribunal that would actually deal with some of these unethical matters. So here in the leadership integrity, we have proposed that, but essentially the legislators did not consider it. Then balancing the rights and interest under Article 38, the political rights, and Article 99(3) of the Constitution. The Article 99(3) of the Constitution generally is in terms of qualification and disqualification for appointment or for elective positions. And one of the things that it puts across is that one needs to have exhausted all of the appeal or review processes or review of those sentences. And again, that would mean that for someone then to actually be debarred, it will be very difficult. Because even if somebody have been impeached, what I need to do is that we will rush to court, file something. It could be a petition, it could be any kind of proceedings there. And essentially, they will clutch and keep on flying that yes, my appeal has not been actually heard and concluded. So that is what has been happening. And I think now for the political class, balancing that Article 38 and 99(3), I think is an area perhaps the courts have not, from authorities that we have, it's one area that the courts have not looked at. Perhaps it will be one area that if a pronouncement would come around that area, would help a lot in terms of shaping Chapter 6 as far as elective positions are concerned. What happens generally you will find many petitions come in almost in the last minute, just prior to the elections. And I think it does not give room again, even for the courts, around that time to look at these issues. So it's a matter, perhaps, if it were to arise early and perhaps be brought for determination, I believe it will give the judiciary a very good room to look at it. In 2017, the National Commission for Human Rights attempted to take an advisory or lodge an advisory opinion at the Supreme Court in terms of what will be the proper test for determination of Chapter 6, among many issues. And it had put in quite a number of authorities in this area. But again, it did not move. I think by that time, Kia Mutata was in the matter, and he raised an objection. He said there are quite a number of matters, similar matters, in the High Court that are still being litigated. So if this advisory opinion were to be heard, it will prejudice those other matters. So the Supreme Court also, in its wisdom, actually referred the matter back to the High Court. In terms of breach of Chapter 6, what are some of the consequences, penalties? We have administrative action can be taken. In many cases also we recommend administrative action that are taken. Not all matters deserve penal consequences. Some can be corrected and we refer them back to the institutions. We have the disciplinary proceedings also can be taken against individuals. Some also cautions are there. We have removal from the office. That will almost be the final end, the tail end. Criminal prosecution. Unethical matters come in various ways. At one stage they are unethical, you go to the next stage, they are actually criminal matters, or they mutate to criminal matters. So that this has been is enhanced public interest litigation on Chapter 6 and related laws. At the Commission, I think almost each and every week hardly passes before you get a petition or where the Commission has been joined as interested party in terms of public interest litigation, where one is actually challenging either appointment or the suitability of somebody that has been appointed. So to me, these are plus in terms of breathing life, in terms of Chapter 6. Because in litigation, public interest litigation is both ways. Even if there's no, at times, even if the petition is dismissed, but there are principles of laws that actually come out, and that becomes very important in terms of advancing Chapter 6. The judiciary is also commended for bold decisions on Chapter 6 of the Constitution. I think we can only do better, but so far there have been quite a number of decisions that have come out very well in terms of promotion of Chapter 6. Then actions by accountability institutions. This is EACC, Auditor General, Controller of Budget, DPP. I think they are also doing good work in terms of accountability to various institutions and even to individuals. So I think to me, this is key and critical in terms of promotion of Chapter 6. Then the increasing demand for accountability by the youth and civil societies. And I cannot belabor on this so much. You can see the youth, the Gen Zs, they are very, very keen. They are actually very, very keen in terms of even the keyboards. Within a very short time, they are able to mobilize and bring out anything that is not good. So to us, that is a good thing in terms of enhancing accountability and transparency. The media, I think the freedom of the media, we have the free media, which is critical. Indeed, it is said that corruption abhors the media. It fears the media so much because the media would actually be able to expose it. So again, the media has done a good job in terms of exposing bad governance, in terms of even exposing whistleblowing issues on corruption, issues of bad leadership, and I think to us that is a good milestone that should be encouraged and be used. The public, again, are very vigilant in terms of and putting pressure. We serve them and you cannot ignore. You ignore them also at your own peril. So to me, that's a good milestone that we need to ride on and we need to encourage. So having looked at those milestones, the fight also has challenges, and perhaps we may want also just to share the challenges, just like a person driving. You would also, like in our Kenyan roads, get a lot of potholes here and there. And in the fight against corruption again, you would likely to get such. And one of them is we have the weaknesses or gaps in the law, whereas the laws may not be foolproof, but we are also seeing quite a number of gaps in some of those laws. We have tried to propose quite a number of amendments in the Anti-Corruption and Economic Crimes Act, in the Leadership and Integrity Act, so that we see what best can be done. Then Article 99(3), which I alluded to, of the Constitution, a person is not disqualified unless all possibility of appeal or review of the relevant sentence or decision has been exhausted. So this has been the biggest challenge, and again, what I said, perhaps there will be need to relook at this in terms of the Bill of Rights, in terms of Article 38 of the Constitution. How do you balance the two articles? Then the general decline of morals in the society. Again, this is a big challenge. Then I'd pointed also the gaps and inconsistencies in judicial interpretations. Again, we do not seem to have a definitive, apart from just one, like the Sonko one on impeachments. Others are still quite a number of inconsistencies. Then politicizing the issues on ethics and integrity and anti-corruption war. Again, these we cannot rule out. At times when you arrest or you call maybe governors, MPs, record statements, some will say that that is our own, that is our governor, whether he's corrupt, that is our MP, whether he's corrupt, leave it to us. So you will see the kind of issues of politics that comes in when you are fighting corruption and also unethical conduct. Then entrenching ethics infrastructure is also a challenge given the big, large size of the public service. We have the counties, we have the national government, we're around almost 900,000 plus. So again, that becomes a challenge. Issues to do with the budgetary constraints, again, resources are scarce, so those provides also a challenge in terms of enforcement. Inadequate support from some stakeholders. Again, this has been key. Others will think that the fight against corruption is just left to the commission. Theirs is they can indulge. If you are caught, it's too bad. It's the commission that is supposed to deal, which is not the case. It is you and me that is supposed to actually fight this vice. So that has been also a challenge in terms of commitment. What is the commitment in the fight against corruption? You try put systems, you can put systems, but if the top leadership is not committed, then you may not have done much. Then weak leadership in devolved governments, we are seeing a problem, and as they provide leadership, either they are joining or they are not providing good leadership. So this has also been a major challenge in the county governments. Again, in terms of challenges, what are some of the proposals that we are making? And some of the proposals we are making is that perhaps we need to enhance public awareness on Chapter 6 and related laws. Again, awareness may not be there, but it's there, but it may not be sufficient. We also need to enhance investigations on ethical breaches and holding violators to account or accountable. And I think this has been working because apart from, it also sends a very strong message in terms of unethical conduct. Then continuous litigation on Chapter 6 and related laws to get judicial interpretation on the gray areas. We have those gray areas that we think perhaps at times you seek amendment of the law or amending some of the Constitution may not be easy, but perhaps the courts may help in terms of clarity, just defining around those areas, like the 99(3) I mentioned about. Then speedy conclusion of corruption cases. I think if the cases are concluded in good time, it helps also in decision making, be it by the suspects, either they are acquitted. So I think that also helps in terms of decision making. because some also have been complaining our cases takes forever, they take long, and they are being used either to malign us or for other ulterior motives. The issue of debarment of those found unfit to hold public positions, I think to me, that's one area, if taken well, again, will send a strong message. And we may also want to keep the bad apples out of the leadership by incorporating ethics and integrity in the curriculum from preschool to university level. Again, this is one area that as a commission we have been working closely with the Kenya Institute. The commission has come up with some strategies like coming up with integrity clubs in schools so that these could be champions be used as champions for integrity. Then continuous engagement with the top leadership across the board in advocating for ethical leadership, that is setting the tone at the top and the tone below. So to me, this is important. It's across every leadership, be it the church, political class, the executive, and other branches. I think that will be important. The tone that has been set at the top helps a lot. The tone and tune at the top helps a lot in informing what is happening even in the institution. So to me, that should be a continuous process. Collaboration, that cannot be overstated. It's necessary. The fight against corruption, we cannot do it alone. We need all the stakeholders. It is too heavy for one person or one institution to do it alone. Then we need also to strengthen clearing or vetting processes for appointment to public office. Again, this is one area that in terms of the law that we have has not been very, very good, but we have used what we have. And one of the things also, as a country, I think it has been embraced as a best practice. And I'm seeing many requests even from private institutions, those private institutions, professional associations that are even considering giving awards. So they are actually using these, and to me, it's a best practice. In as much as there could be some gaps in the law, but they have adopted it as a best practice, which to me is a plus. Then issues on enforcement of the law and codes of conduct, I think I can't overemphasize on that. Civic education for the citizenry to elect leaders of integrity. This is where we have the biggest challenge in the country, because at the end of the day, in terms of democratic process, they are the final, citizens are the final decision. We need a paradigm shift so that we are able to carry them along, so that we will not say, this is our thief, and we have to elect. Even if he's our thief, we have to elect. So I think that paradigm shift is something that we need, each and every one of us need to work on. It's a big...
We are being honest with judiciary takes the flag over a matter that is not actually entirely within their control. So what is it that EACC is doing to ensure that once you take a matter to court, these matters are prosecuted with vigor and concluded in good time?
Thank you. My name is Benjamin Musyoki. Thank you, Mr. Winnie. You pointed out that it would appear from your presentation that there are different yardsticks for elective posts and public appointments. And you say that there's no definitive answer to that, but you've not given us any proposal. And I'm asking this because for the few I've seen from the EACC, you'll find a public litigator, Mtata will come with a petition. They are claiming that Judge Muteti is not qualified because he is facing 1, 2, 3, 4, and he has unresolved issues. The EACC is a respondent in that petition, and it decides to sit on the fence. Yet, we expect to have the details and information from the same EACC. And they are courageously telling you that we are not taking stand. How does that where does that place the court? Do you expect the court to be to take the responsibility of the SEC to evaluate the suitability of these candidates? Because I don't believe this war will be won by having cases in courts. Everybody must take their responsibility. So I would just want to have your comment on those two issues. Where do we stand with these two, or what is your proposal on these two yardsticks? And how does the ESCC help the court to resolve some of these issues instead of sitting on the fence and waiting for the public square it out? Thank you.
Maybe I start by commending Patrick of the ESCC and make a disclosure that I personally have a history with Patrick. I've worked with him on the subject. My comment on this issue is, I think the constitution makers were deliberate in the terminologies they used. Here we are discussing public officers and state officers. And I'm also alive to the fact that the ESCC has so motu powers under the Leadership and Integrity Act, which I would want Patrick to speak to, Section 42, subsection 10, as the initial port of call. And I agree with Judge Musyoki that not everything should come to the court. Various actors need to take action within their various ministries, departments, and agencies. Now, I'm linking this comment to the blatant disregard of court orders by public officers, and relating that to the provisions of Section 42, subsection 10. And from the ESCC perspective, could the court then refer instances where the court believes there's been a breach of leadership and integrity by either public officers or state officers to the ESCC to initiate the inquiry and act accordingly? I would want to hear more from that direction.
May I go next? Thank you. Thank you very much, Mr. Owini, for your very elaborate presentation. I would like to just raise some 3 points. One is that, and I'm not saying that we should go to that full extent, but in some countries like China, corruption is punished by death. And though in Kenya we do not enforce the death sentence, is there a consideration that penalties for corruption cases should be enhanced? And could that be part of what you have proposed in your amendments? Second thing I have pointed out here is that we have cases of past orders from above. Now, is this a situation where we should have command responsibility being taken to where the orders came from? Is the issue?
Francis, he wanted to know how you can serve the court. My question is, why you do not participate in such important proceedings to your mandate, and whether that is not an issue of integrity within the framing of the theme of this summit. Thank you.
Thank you. I will attempt to answer those that I can. I may not be exhaustive. The first one was corruption pays, and there could be negotiations with the political honchos in terms essentially in terms of even public interest. It is not proper. The court also has a duty. If the court would think this is an illegality or is not properly done, I'm sure the court can also intervene. But essentially, there's a lot of the criminal proceedings going on, and again, in terms of a suit that has been filed for asset recovery, the asset recovery is going on. So there are many things or dynamics that are involved. But I would also, if I had a case-by-case situation, perhaps I would have been able to dissect and maybe answer well. In terms of the second question was the Samburu governor, Lennon Kulal, and in terms of, he was indicating that essentially if that perhaps 99 was applied and later on acquitted, perhaps wouldn't that cause an injustice? You remember in my presentation I said this is a delicate balance. You are balancing the rights under Article 38 and again the right perhaps on issues on integrity, issues of leadership and integrity. And again, I indicated that these are one of the areas that to the public, they would actually say, this is a person facing criminal charges. And as far as the ethical threshold is concerned, to us, this is a person that should not be appointed. But you see now the divide, the criminal threshold and the ethical threshold. Which one do we adopt? Which one do you adopt? And these are the areas that I was saying is still gray in terms of courts are not coming out very, very, very clearly. Or the mindset is perhaps beyond reasonable doubt. And therefore, in terms of enforcement of ethical, that should not be the case. You need to stop this person. IBC need to stop this person. So where do we hold, or how do we help in that kind of a situation? So that is the dilemma that we are in, and that's why I was saying that perhaps we do not have a very definite pronouncements around that, balancing Article 38 and 99. And let me tell you for one, like for many cases, even for those that have been convicted, you will find that they may even keep quiet, but last minute, they don't even appeal. But in between, they have thought that they have to go for politics. And now they are filing some proceedings. And once they have filed some proceedings, the Article 99 come in. And what I was also saying that, do we look at in as much as we also look at the Bill of Rights or the right to appeal, but do we also look at it that perhaps that 99 also can be abused by the political class? So there are all those elements that perhaps need to be taken into consideration. Then again, qualifications, we are saying that there are some top leadership and perhaps we have not gone for them. As far as I know, a number of those with forged certificates, we have actually prosecuted or under investigation. Unless, again, I get a specific case by case, then I will be able to answer. I may not want also to generalize, but I think we have dealt with quite a number of top officials or top public officers. Then there was the issue of delays. Where does the delay come from? Is it the EACC? And or where does it come from? I have a practical example. I will say the Nairobi anti-corruption courts. I would actually want to commend them, both the High Court and the Chief Magistrate Court. The pre-trials are, somebody takes plea, the pre-trials are done well, the documents are exchanged, and they are actually up to speed. So I would actually commend. But for courts outside Nairobi, from where I sit, I can actually tell you that it has not been good. I take 3 witnesses. They have actually been flown perhaps to Eldoret. They reach, it's on a Monday. You have actually traveled with 3 witnesses or 4 witnesses. You arrive in a station on a Monday, and you are told the court is not sitting today. Either the magistrate is indisposed or he has gone for a training. And no notice has been given. And it's not once, not twice, not thrice. You look at the time EACC to actually investigate. So you look which one will be easier, will be participation. Persons not obeying the orders, to me, that will, public officers, that will also be unethical, an area that as a commission we can get involved in. Commission, the other one again was commission not getting involved in proceedings. It is among the reports that I need also to pass over to the management. Thank you.
Thank you, Patrick. We of the presentation. Any other questions? talk to Patrick. I can see some hands up, but you can talk to him during lunchtime or tea time. For now, I'll call upon Josephine, who could not be traced some time back, to just say something in 1 minute. And after Josephine, we shall have the principal judge make an announcement.
Mine is a public service announcement. As you're aware, I am now a trustee in the Judges Welfare Trust Fund, and I just wanted to let
This afternoon, we have 4 distinguished presenters. It is a panel. We have 4 distinguished presenters and the panel moderator. And the topic that we are going to discuss is ethical leadership in public finance, human rights dimensions of taxation, and debt management. Our presenters today are all present, and we have been having this conversation since yesterday, and we were told the conversation continues. The issues of ethical leadership is not something we can be able to handle in one summit or 2. It is a conversation that we have to keep talking about. But we appreciate the leadership of the High Court, being led by the Principal Judge, for giving us this opportunity to discuss this topic. And some of the issues that we have picked from the presenters is that we should decolonize justice. Yes, so that justice is easily available and we are better understood. Then we combat impunity. And all this duty is left to us. And we were referred to as sanctified paupers. Yes, that notwithstanding, we will do what we can do because we think we are here by choice, isn't it? Yes, we all applied for the job and we are where we belong. And at the end of the day, we were told about transformative ethical leadership, not just leadership. So let us not distort justice systems, and let us not erode the rule of law. And this is about us as the institution and as each of us individual judges. So it is not about the High Court in general. Yes, as an institution, judiciary, yes. High Court, yes. But it boils down to each one of us. So having said that, I now want to introduce the panelists for today. And I will start with Mr. Alexander Rithi. When you look at your program, most of the presenters for this afternoon have changed. So when you hear me read different names from what is in the program, it is because it has been amended. So I'll read for you the amended version. So we have one Alexander Rithi. Please project his CV. You can see the CV of Mr. Alexander. I will not go through it. Please pick something from there. What I did say is that he's the head of programs in the Institute of Social Accountability. Mr. Alexander, please, I welcome you. Please let us put our hands together for Mr. Alexander. Yes, the other presenter is Dr. Henley Geshana. This one works for Katiba Institute. All of us know Katiba. I mean, all of us know Katiba Institute. He's the executive director, Katiba Institute. Please give him a clap. Oh, head of. Oh, okay. Sorry, I've been given the log. He says he's the head of Rigo and Research. Please give him another hand of applause. Then we have Jason Braganza. I don't know whether I've pronounced it correctly. Yes. He's the head of, he's the coordinator of African Forum and Network on Debt and Development. Please give him another applause. Then we have Leonard Wanyama. I hope you are projecting as we go along. Yes, we have Mr. Leonard Wanyama, who is the coordinator of African Forum and Network on Development, on Debt and Development. Finally, we have Madam Ajera Wangeshi. He's the program coordinator of the Institute of Social Accountability. Please give her a round of applause. Yes, this session is a bit different. she's the one moderating. Okay. Some small housekeeping issues. We are dealing with suits that have been filed out of time and a certificate of urgency in terms of amendment of the program. So this discussion, this will be a panel discussion. It will not be in the form of presentations. And we have Madam Majara, she's the one who will be moderating. Now we have 2 hours for this session, and we will have some time for Q&A after that. I'm suggesting that you can take 1.5 hours in presentation and everything. Then we can leave 30 minutes for Q&A. Yes, and without much ado, I hereby hand over the program to Madam Wangeshi.
Thank you very much, and good afternoon, honorable judges, judicial officers. I know we have independent institutions in the room, and our fellow civil society representatives and citizens as well. So good afternoon. Yes, I know it's after lunch. I know it's very hot in here, and that is why we thought that it would be better that we have a conversation rather than have presentations. I hope this helps to try and keep us alert. Yeah, we are here with my panelists, and I apologize. I know that gender is not balanced, but we had to do what we have to do. And I think as human beings, flexibility is one of the ways to survive. And so when our female panelist could not make it, we had to quickly find a way to ensure that this session happens. So we are very aware of that, and it is not intentional. So our conversation today, we want to focus on ethical leadership, but also tied to tax justice and human rights. And because that would mean fairness, equity, and also equal distribution of both burdens and benefits. So I would want us to start our conversation from that point, because in most cases, we have some misalignment when it comes to that. And so we want to look at taxation as the driver of some of these mishappenings. And so we are going to look at, constitutionalism, human dignity, and the ethical leadership, and how we are able to address some of the issues that have been happening. So I want to start with, on my right, maybe we could start with you, Jason. Yes, because so when we talk about tax is about raising revenues. But I think when we talk about raising revenues, we raise revenue so that we can spend. And so the problem we are having as a country now, especially when we look at public debt, has been really, really, really driving our tax conversation, maybe in a way that we know or we don't know. And so we have seen government borrowing a lot, and that has been affecting a number of services. It has also affected the way private sector also access resources. So I would want us to start from that point, Jason, and maybe try and unpack how the domestic revenue mobilization has been affected by our debt trajectory, so that we can start our conversation on human rights from that angle.
Great. Thank you very much, Angela. And allow me to stand on the protocols that have already been observed from earlier on today. And maybe just one clarification as I give my submission. I'll be submitting in an independent capacity, so the thoughts and reflections do not necessarily, while might be linked or similar to, do not necessarily reflect the views of the African Forum and Network on Debt and Development. I think first and foremost, when we start thinking about how the intersection between debt and taxation comes to become an issue of human rights and dignity, and as well as upholding different types of social arrangements between citizen and the state, we need to go back to some of our fundamentals. And the first one there is the social contract that exists between citizen and the state. That is the cornerstone between what defines the relationship between what a citizen pays in the form of taxation, in response or in return for by the state in the provision of public services. And I think over time, the terms and conditions or the parameters of that social contract have evolved as history moves, but also the responsibilities of those two parties has also changed to quite a great extent. And we're beginning to see this, or have been observing this for at least the last 20, 30 years, when we've seen a lot of involvement and high pace inclusion of private sector and private entities in being part of this social contract, and particularly in facilitating the role of government in providing those public services, but through private means. And so what you tend to then start observing is that the taxes that citizens are paying are not necessarily going towards investments in the universality and the expansion of those public services that would then, be considered as part of addressing and upholding the human rights and citizen rights under this social contract. And there are quite a number of explanations that can be given for this. The very first one is, if you look at how our leadership on the continent, let me use the continent as an example before trying to draw down to Kenya specifically, is that we have tended towards outsourcing our economic development. We've tended towards outsourcing our economic transformation agenda. And if you look at many African countries since independence, very few of them have actually transformed their economies from being colonial, extractive, primary commodity dependent economies. Many of our countries on the continent are still the same. But within that same 60 or 65-year period since independence, our populations have grown, our populations are more educated, our populations are a lot more expectant in terms of what the state should do. But the ability of the resource capability and availability of the state has not increased at the pace at which the population has risen, or at pace at which the demand for public services has also risen. And as a result of that, our governments have largely outsourced the ability to transform their resources to private individuals, which means you are lowering your incentive structures to attract foreign direct investment. You are attracting foreign capital, foreign businesses, at the expense of actually building your own domestic resource capabilities. And so automatically you have what you call deficits, because you're exporting coffee beans to import ready-made coffee, right? That's the kind of situation that we are currently facing. So that's one of the explanations that we can use to start thinking about why is it that tax issues and debt issues that we are currently facing today become an issue of human rights. We need to go back in history a little bit and understand how the social contract has been designed on our continent. The second part of this is the deepening or the entrenching of a reduced state intervention in the development trajectory and in the development pathway of our countries. Many of our governments tend to believe that privatization is the only way to achieve economic development and economic transformation. Actually, it's not. We've seen in other parts of the world, India, Brazil, China, our president here has been talking about the countries in the in the East Asian tigers. All of those countries have become advanced economies, not through through neoliberal privatization, but through a very dedicated period of state intervention and what we call a development state economic development model. And so there is a very critical role for the state to play in actually ensuring that the domestic resource mobilization conversation becomes part of ensuring that those rights are upheld and the human rights are upheld through taxation and debt. And the last point, just by way of introduction, that is important in the more present day is that because of this very rudimentary economic structure that we have, coupled with this very this obsession with private sector, let me be very clear, foreign private sector led growth and export led growth, together with the diversion or the lack of advancement in our economic structure has led to a situation where the taxes that are being developed or being generated by our countries and our governments are just not enough to fulfill the public demands on public services that are needed. And so these three things together, coupled with the vulnerability of our economies to economic shocks, to climate shocks, to political shocks like we've seen COVID-19, we've seen what happens when we have hurricanes and typhoons in the southern part of Africa. We've seen what happens when we have famines in northern Kenya or North Africa, or we've seen what happens when we have political unrest in Central and West Africa. Many of our economies are not able to contain those shocks with the revenues and the economic structure that they have. And as a result of that, governments are being forced to borrow over and over again. They are being forced to divert the minimal tax revenues that they generate towards debt servicing in order to keep up or be in good standing with their creditors. So the starting point really, when we're trying to bring this intersection between tax, debt, and human rights, is to really go back to the social contract and understand how does it connect with the economic trajectory of the country, of our continent, of our people. How does it link with the transformation of moving from a primary rudimentary economic structure to a more industrialized manufacturing job-creating structure, and to diversify away from this foreign-led, export-led type of growth model, but instead look inwards. It's very clear outside of Africa, if you look at Europe, if you look at China, if you look at North America, the USA in particular, all of these regions and all of these countries are looking inward. They are all introducing policies that protect their own domestic industry. They are all engaging in international conversations that protect their own domestic sectors. And I think that intersection between tax, debt, human rights, and how the debt situation becomes a tax issue it's all between citizen and the state. Thank you.
Thank you very much, Jason. And I like the way you've brought out, especially the issues of the social contract. And thinking about what you've brought about, even the privatization and the debt issue, I think we have seen our government now. Of course, we know where we are with our debt, but I think our government is now exploring a different way of economic development. And so maybe Dr. Gishana, you could speak to this, because we've seen, I think the talk in town now is public-private partnerships. And the government is looking at it as an alternative, probably to public debt, or maybe you could tell us. But I know there are so many conversations going on. So probably you could tell us, for a start, what are the misconceptions? Is it a good thing? And how is it panning out for us now? And of course, how is it affecting us as citizens?
Thanks a lot, Angela, for that. And let me start by thanking the lady judge for the prophetic words she uttered over me. It's not every day you have your elders uttering prophetically or speaking prophetically in your behalf. I'm not the executive director of Katiba Institute. I am in charge of devolution and public finance at Katiba Institute. But when the prophetic words come true, I'll definitely come back and thank the good lady judge. So just to speak briefly about public-private partnerships, I'm sure most of us, at least from our side of things, became aware of public-private partnerships last year in the middle of all conversations around the projects, the upgrading of the Jomo Kenyatta International Airport and energy projects relating to KETRACO, and ideally getting to understand really what are public-private partnerships, what prospects or what advantages do they present, and what are look, we have assessed the project, be able to provide these public services. You will not have to pay us directly. Obviously, there are other options where the government agrees to pay directly, annually, what are called annuities or availability payments. But in most cases, the private party comes and says, look, we have money, we want to develop this particular project, but in return, we are going to impose fees for access to these particular services, either through tariffs or toll payments for roads. A good example of a PPP project is the expressway. And for those who use the expressway, you understand once you go through, you get to pay for it. So essentially what the government has done, it has given up its responsibility to collect taxes, use those taxes to provide a public service, and instead it has delegated that obligation to a private party that, look, you can develop that particular project and collect and or rather recoup your expenses directly from the people. Now, they are not free because as part of that PPP arrangement comes with fiscal commitments. You make financial commitments, either that I'm going to pay annually or in the event. So there's usually what we call minimum revenue standards. For example, when you are entering into an agreement with the developer of the expressway, you will indicate that on average, you're going to get about 20,000 cars using the expressway. That is the minimum. So in the event that that minimum threshold is not met, there are obligations where the national government now has to come in and be able to top up the annual payment towards that infrastructure project. So there are fiscal commitments, and in addition to those fiscal commitments, there are also risks. Foreign exchange risks, political risks, legal risks with respect to change of laws, the various risks which either the national government bears or the private party bears. So when those risks are in the future, they're not coexisting at the moment. But in the event those risks come to pass, then the national government adopts financial obligations. For example, if there is a foreign exchange risk and there is a change in the exchange rate between the dollar and the Kenyan shilling, which then increases the amount of money that the national government has to pay, then it has to assume those obligations. So essentially, therefore, PPPs, as much as they have their own efficiencies, are not cost-free. They come with fiscal commitments and contingent liabilities which can be triggered due to the occurrence of an event in the future. The second misconception largely is that PPPs are cheaper options compared to developing infrastructure or providing public services using public resources. That's not true. Remember, we are bringing in a private party to provide or to erect a public infrastructure. The interest is not in the provision of public infrastructure. The interest in actually making returns. And returns is profit. When a government constructs a road, the end goal is to provide services, to provide access for those who need to use the road. But a private party comes in, and remember, these are not concessional loans. The amount that they are supposed to recoup is on commercial terms. So essentially, in the long term, PPPs may end up being more expensive than using public resources to be able to construct infrastructure or provide public services. The only efficiency PPPs provide is you don't have all that money at the beginning. For the national government to be able to construct, say, for example, the expressway using its own resources upfront, it requires a significant amount of money upfront, which it may not be able to have. So PPPs provide efficiencies, but they're not necessarily cheaper. And the last misconception that I wanted to highlight is with respect to the reduction of public debt, that it's a way of reducing public debt. We've already indicated that PPPs are essentially debt. It's money, instead of giving the money to you, I'm using the money on your behalf, and I'm going to put in an effort to recover the money directly from the people. So those are the few misconceptions that I want to mention, but PPPs do provide efficiencies. For example, if I am to give a loan to the government, they're going to receive this money and use that money to construct. In between receiving this money and actually using the money to construct, there are usually leakages, okay? Because it's public money. It's a tragedy of the commons. The more you have access to that public funds and very little checks and balances, a lot of money gets wasted, deals are cut. But when you bring in a private party, the efficiencies that come with ensuring that money is used prudently from a commercial point of view to ensure that particular service is provided. Yes, PPPs provide the efficiency. So the one advantage is that money that the private party uses to construct or provide public services, they do not, the money, the total amount does not go to the government's books. Essentially, it means your balance sheet does not reflect that billions of shillings which were used to construct the highway. And therefore, you can still go out there in the market and say, look at my books, they're really in good order, and therefore be able to access credit. So they are referred to as off-balance sheet financing, but it doesn't mean that you don't get to pay them at the end of the day. You get to pay them. They increase your ability to be able to access credit and money to be able to provide services, but they're not cost-free. They're not cheaper than public provision of those services, and they don't necessarily reduce our amount of debt.
Thank you. Thank you very much for breaking that down, because I think it's really been in our space, and it is important to, like, when we're engaging, we have a clear, understanding of what is it we are talking about. And I want to pick it from where you have left to the inequalities and the tax justice angle. And so, Leonard, I know you have been in this space for a while, dealing with taxes and the human rights aspect of it. But I want us to pick up from where Jason and Dr. Gishana have left it and unpack for us how that inequality is panning out, because we have heard about the future, we have about the commitments that come about, the interests, and also the risks that, will come about when we go this route. And of course, what we have seen with our debt issues. So please unpack the inequalities that are being propagated by such frameworks, and just let us know, like, for example, for someone who is new to those issues, what are these taxes that probably are very retrogressive, that are propagating a lot of inequalities for the citizens?
Thank you very much, Angela. I'll also do a slight correction. As had been introduced earlier, my name is Leonard Wanyama, and I am the regional coordinator of the East African Tax and Governance Network. To delve into the conversation, you might have seen in the news the other day about the state of inequality in this country, where they said 125 people have most of the money compared to the rest. And as the conversation was kind of taking place, I noted, like, just by looking by the arrangement, 125 people could be about this number, and the rest of Kenya is everyone else who's out there not having access to that kind of wealth. Because when I count, it's about 200 people And you can imagine, how is that the case? Essentially, what you realize is that these are structural questions. These are systemic questions. And aside from the very good bio that was presented to you, I am here primarily because my qualification is that I am a citizen. And for most citizens, they might not have even had the opportunity to meet as many lords and lady justices as I have met today, or as I am speaking to today. And this is systemic, because if for my case, if I consider myself privileged in one way or the other, this is like an exceptional place to be in. You can imagine all the other Kenyans who maybe don't even have a justice in their family. Maybe some might not even have their case reaching a court somewhere. Maybe it's just dealt with a chief. And so these are structural things that are in there. Particularly in the space of taxation, this is an avenue that is also a very niche space, dominated by lawyers, and not even economists, but accountants. So for very many people, we don't know how to begin even tackling the matter. Now we have to take the question of inequality, the question of laws in the context of history. And if you look at the history of this country and the coming into the Constitution of 2010, that was a struggle to achieve certain rights. But now, as the Constitution awakens, a lot of the things you're seeing in politics, in the courts, for instance, some of you might have cases brought to you discussing public finance, is the Constitution now arising to the question of, once we have these rights, who has these responsibilities? And once we know who has these responsibilities, then every citizen, in an ideal majority of us, need to understand what rulings, what law, what every other action is supposed to be for them. Now, the point you realize about not only tax but the wide space of public finance is that the easiest way to begin making this subject understandable is the question of adopting a human rights-based approach to taxation, to understanding debt, to understanding trade, to understanding tax treaties or any other obligations that could be before us. And then with that, you begin to understand very clearly what and how to address the inequality. There are 5 main principles to this. I would imagine for you, a lot of this will be examining what is in terms of thresholds and so forth, and whether it has been fair. Secondly, examining and ensuring and exploring the fact that people have been made aware about these laws. Thirdly, the fact that these laws should be non-discriminative. Fourth, law, the Constitution, should also empower people. And then lastly, that law is legitimate. Now, to focus a bit on the law being legitimate, and speaking directly to what happened in 2024 and what happened in 2025 in terms of the protests, what you see is whenever structures and systems are not, in this case, representative to those who are protesting, they immediately push it towards illegitimacy. Why? Because of 3 things. They feel that the rule of law has not been applied. Secondly, they don't understand it. So the question of language. When you say that you're taxing withholding tax, for some people, what do they mean? What does that mean for them? Or there is a tax that because you're a informal business, you pay beforehand so that you're not taxed again. These kinds of things in terms of language are really important. And then thirdly is the logic. In terms of the logic, for instance, as professionals, we are probably very stuck on the fact that we are looking at the process and the procedure. But for the citizens, they are really keen to understand the question of fairness, the question of functionality, and the question of facilitation. And I'll give an example in this case. And this case particularly has a historical bearing. There was a recommendation that we will have revenue service agents or officers who were trained military, and they even went to, I think that was RTC Eldoret, got training there. These were KRA officers. And you could see from the public there was a great resistance. Because first they just had that idea of the military has figured out another way of entering into taxation. And then they didn't understand even the recruitment, and I think there was some case about that, but that was kind of ruled on. But the thing and the logic here that people don't understand, and why, for instance, courts help us navigate these questions, is because in our history, the first institution to collect tax was the military. And so the moment they associated KRA with the military, resistance began. Because when you speak to old people, they tell you how they were chased with Land Rovers in the colonial times to give taxes and give blood donation in those times. Now, again, they are hearing something like that recurring. And then after just that psyche issue, they understand that probably there will be some harassment, and that is unfair. And so it's really important to navigate that by understanding those questions. Why? Because from the citizen's perspective, and if I take the example of what Professor Mahmoud Mamdani has said in his thesis, he says, governments are about citizens and subjects. But what they see is that when it comes to the law, it's about client and subject. If you're not someone's client or in that kind of frame, you're a subject. But what we'd like to get to in terms of the conversation of inequality and fairness, be it in provision of services and so forth, is that even if you are a client, you are still a citizen. And we are always carrying that badge of being citizen and treated as citizens. And there is some assurance that as citizens, the law will stand for you. And in that case, then we can navigate a whole number of issues in terms of the sentiment of citizens themselves, but also in how they get to relate to complex subjects, be it debt, be it PPPs, or be it taxation. So that we shouldn't be seeing or hearing, when you hear KRA, in fact, you see lots of people, it's like they want to go for psychoanalysis or psychiatric help. They're like, you are a taxman. You know, for me, I say I come from East African Tax and Governance Network. Some policemen even can open the gate for me. They say, "Hiyo badge yako ni ya KRA," because everyone feels that pinch. They're like, "When you mtu wa tax," and that's not the case. We need to go back to that patriotic sense of like, it's our obligation, and this is what we need to do. And just to close, collected. When you go to allocation, when you go to expenditure, again, there are a whole series of responsibilities, which I believe a fair, just system will ensure the human rights for all. Thanks.
Thank you very much, Leonard. And it just reminded me of, I think I've seen in the social media recently, everyone is talking about KRA sent me, told me I'm supposed to pay 800. Someone else responds, they also reached out, they're expecting 200 from me. So it's a feeling that the citizens have, and maybe to pick up from here, maybe Alex, I know TISA works a lot with the citizens, and just to link up the issue of the taxes and the debts that we are paying. we got introduced to the social contract, and Dr. Gishana has spoken to how PPP is trying, to see how we, maybe resolve our debt problems, but from the citizens' point of view, because we know for economics like you know how debt servicing projections look like for next year. So, as citizens are running away from KRA and the debt on this other side, so how do we now ensure that human rights are observed, that sustainability is also achieved, even as we try? And probably in the first place, how is the feeling? How does it look like for this citizen from that aspect?
Thank you very much, Angela, and my ladies and my lords and ladies. Thank you for the opportunity. And at the expense of breaking protocol, I want to give a shout out to Justice Gidenji. Good to see you in this forum. We meet in other areas. Now, looking at the issue of debt and taxation and how it links up with the common man in the streets. For a long time, citizens have been seeing the issue of debt as an issue that does not touch them. It is the government that borrowed. They will know how they are going to pay. It has nothing to do with me. Until very recently, where now we are having a situation where out of every 10 shillings that we collect as ordinary revenue, that is from our taxes, 7 shillings goes to debt repayment. What this means is we only retain 3 shillings for our operations. So if you look at now from an economic point of view, there are certain graphs that we've been observing over time. And I've given you a report that we launched yesterday called the People's Audit. And you will, inside there, see a graph that shows the amount of money that has been going to debt servicing vis-a-vis service provision, be it health, be it education, roads, and so on. So what has been happening, instead of our taxes going to provide services to us, we have more and more taxes going into debt servicing. That is why now we are seeing a problem arising when it comes to education. We have the whole story of capitation declining. We have the whole issue of our hospitals going without medicine, and this has a link directly with debt. Most recently, as Dr. Gishana had started explaining, we have now a situation where our debt levels, we are in what we call the country is in debt distress, where our capacity to absorb more debt is limited. So now, what the government is currently trying to do is, one, starting from what happened last year, we had a debt of $2 billion that was maturing by June. That is why if you saw the US dollar in January of last year had gone all the way to 163, because there was an expectation that Kenya would default. What happened is we bought back the Eurobond, which we had acquired at an interest rate of 6.something%, and we bought it back at 10.6%, meaning you are buying or you're selling your loan, which is cheaper, and acquiring a more expensive loan that you kick down the road. So that particular Eurobond that we kicked down the road, by the year 2028, it will be maturing again. So we will still find ourselves in the same situation, and in 2027 we have another Eurobond that will be maturing. Now, what this has done, given that now that space to borrow has become so limited, what we are currently doing is to try and do off-the-book borrowing. One of the direct borrowings that has happened that now affects every Kenyan every day is what we are calling securitization. The first securitization was securitizing our fuel levy. Out of every liter of fuel you are consuming today, you are paying directly a debt of 7 shillings. Forget about what we are paying in taxes. You know that is indirect because you don't get to see it. You pay your payee and then government does its math and they pay off. But today, Anybody who fueled this morning, out of every liter, you pay directly from your pocket 7 shillings to debt repayment. We have now the stadium that we are building on Gong Road has also been securitized. Meaning we are making use of revenue streams that we have not already collected. This ties any future government to these economic policies that we are coming up with. And the question is, does it mean now the economic policies we are having today will still be feasible in the coming years? Just to jog your mind, all of us in this room, or a good number of us, are paying housing levy. Is that the case? Now, in the unlikely event, or the likely event, that we now securitize the housing levy, and we get what we are supposed to collect in the next, say, 10 years, it will mean that whichever government that comes our way cannot abolish that particular levy, because there is already a debt that is attached to it. Now, the talk in town today is the divestiture that is happening at Safaricom. There is another interesting borrowing that is happening there. We now want to collect our dividends upfront for the next, is it 5 years? I think it's around 40 billion or thereabout. So what this means, again, that is another debt we are accruing. What happens if the risks that Geshana has said actually come to pass? It will mean that we will have actually to pay back the person that we have gotten these dividends from. So at the end of the day, from a human rights perspective, if you look at Article 43 of our Constitution, that provides for our rights to education, our rights to health, our rights to food, we are going against that and repaying debt first, instead of providing services to our people, which is a right. And that is why in your benches, you will see us coming with various petitions, because our view is, yes, we have these debt obligations, but these debt obligations should be to the extent that we first of all honor the human rights that are within our Constitution and provide the services that we ought to provide. At the same time, we pay debt that is commensurate with what we are acquiring. Now, the other angle is, out of all the debt that we are acquiring, given that we need to pay, kwa sababu deni ya dawa ya deni ni kulipa. And if we don't have enough money to repay, what happens? We go now back to taxation. That is why you saw what happened last year. Because now, actually from 2023, because now what government has been trying to do is look for ways of increasing our revenue. And this is through increasing taxation. When you increase taxation, there are many other things that happen, because it means some of our products, if it's food products, essential products, will become more expensive. That is why the issues of inequality will go higher and higher. And the issues of inequality have a gender perspective. The first obligation of any family is to ensure that there is food on the table. And when we do our studies, between, and allow me to be feminist a bit here, between men and women, who are more responsible for food in any household? Is women. So if food is expensive and unbearable, who suffers more between men and women? It is women and children. They will suffer more. So we are continuing to press the women and the children more and more. Now we have now this issue of education. If we are spending most of our money to debt repayment, what happens to education? The reason why I'm sitting in front of you today, a big part of it is because I went to school. If I didn't go to school, chances are I will not be sitting in front of lords and ladies as I am today. But now what are we doing to our future generation? If we are reducing capitation, if we are reducing infrastructure in our schools because we are doing debt repayment. Infrastructure is good, but there should be a limit to which we now commit future revenues to infrastructure. Because what happens with infrastructure, and I'm an economist, it doesn't give you immediate returns. It is long term. So you should have a balance between future revenue streams and current revenue streams. That is where we went wrong as a country, and what we have done, and I encourage you, my lords and my ladies, to take a look at the document that we have prepared And this has been circulated across the country because we want everybody to read and understand where the rain started beating us. Maybe finally, Angela, as I stop, I wanted to bring to your attention the fact that even the debt situation that we are in as a country, we have now 54% of our debt being domestic debt, meaning we owe local people, local banks, insurance companies, trusts, and pension funds more than we owe external partners. Now, the worst bit is most of the money that we owe internal partners, that is banks, pension funds, and so on, went to what we call budget support. It is not linked directly to a certain project. If you look at what we have borrowed from, say, China, World Bank, and so on, you'll find most of it is linked directly to a certain project. But what we are borrowing every other Thursday through treasury bills and bonds, most of it goes into recurrent expenditure. Unfortunately, last financial year, we crossed the 1 trillion mark in terms of domestic debt service. And in this particular financial year, we are likely to cross the 1.5 trillion mark in terms of domestic debt service only. So this is an issue that you will continuously see us bringing on your benches because it has a direct correlation with taxes and respecting the human rights that we have in our constitution. Thank you.
Thank you. Thank you very much, Alex, for painting that picture. And maybe, Jason, you could help us, in the work that all of us have been doing. How are we ready? Or probably we don't have, solutions that will solve the problem, but how do we make milestones in addressing, some of these problems, especially as a country and where we are headed? What are some of the recommendations that we would give that could help us make a few steps as we try and resolve this problem?
Thank you very much, Angela. And I think just to complement what my fellow panelists have said, there are actually very many solutions out there. I think the challenge both for citizens and for government and the esteemed institutions of governance on our continent, such as the judiciary and parliaments and so on, is to really take the bull by the horns to try and curb this debt crisis that we're facing. And allow me just to proffer 3 or 4 options that start from the national level and can actually move up into what can be normative things we can do at the continental and international level. First and foremost, the organization I used to work for, called the African Forum and Network on Debt and Development, have something called the African Borrowing Charter. It is a blueprint of how to strengthen transparency, accountability, and public governance of government borrowing. And here it empowers parliaments, judiciaries, citizens, members of the Fourth Estate to pay keen interest in how government borrowing operations are being done. And this can be done in a number of ways. I think first and foremost, a country like Kenya actually is quite progressive with its legislation and its policy framework. What is lacking is the will to implement and to execute what is in the legislation, execute what is in the policy document, because of whatever overreaches or tentacles that may come from other directions. And we are seeing this very clearly in the description that has been provided from my fellow panelists. I think it's important that parliaments across the continent are empowered to call ministers or those who are in charge of ministries of finance and national treasuries to answer questions around their borrowing plans. Yes, countries have medium-term expenditure frameworks, they have medium-term debt strategies, medium-term borrowing plans, but on very few occasions do these ministries or ministers or directors come to the parliament and explain to the parliament in terms of what is happening. So I think empowering and continuing to advocate and activate parliamentarians to take a deeper interest in government operations, particularly when it's borrowing, is critically important, because I think we'll get a better understanding of why then governments opt for public-private partnerships. Governments will opt for divesting away from tax revenue to debt instruments, and the distinguishing between commercial lenders, both international and domestic, or bilateral lenders, whether you have the old ones or the new ones. Because all of that is very important. Our creditor landscape as a country, as a continent, has changed very much. So parliamentarians need to have oversight of that. Our bilateral lenders are no longer European countries and the Americas. We have China, we have Russia, we have India, we have the Gulf states. They are no longer the traditional multilateral lenders like the World Bank and the IMF or the African Development Bank. We have Afro-Exim. These are development financial institutions like the Trade and Development Bank. We've got different export-import banks in Africa, in Asia, in Latin America, in Europe, in the Middle East, that are all lending different credit lines to our governments to implement development projects. We have commercial lenders from international financial capital markets. So these are the bondholders, some of who Alex has referred to. Eurobond, Panda bonds. You've heard of Panda bonds, you've heard of Masala bonds, you've heard of Samurai bonds. All of these are international capital market debt instruments. Our parliamentarians need to be part and parcel of this. But in addition to that, the judiciary also needs to be very much empowered to be able to interpret and design and guide on legislation that governs the public financial framework in our countries. They should be able to be empowered to be the first point of contact in case of a dispute, or the first point of contact of interpreting these debt contracts should our countries not be able to pay or should want to enter some sort of restructuring process. At the moment, if you cannot restructure, you've got to go to an international process, which is extremely timely, extremely costly, and at the same time, as my fellow colleagues have said on the panel, the tax and human rights cost continues to rise. So empowerment of parliamentarians, empowerment of the judiciary to be part and parcel at the national level of public debt management, accountability and transparency is extremely important. I think, and this does not only mean holding government to account for its borrowing. I think the judiciary and the parliament need to be able to also command and summon the lenders and ask them, why are you lending money? We do not see what is happening with this money that you're lending. You've got to ask questions on the terms and conditions. We've seen this more recently. If you recall, for those of you who might have been following, Mozambique, a very famous scandal called the tuna bond scandal, where an international bank was lending money, Credit Suisse was lending money to the government of Mozambique to invest in fisheries and other types of development projects, but that money was actually being squandered. But because of there not being any oversight, that money was lost, and eventually civil society organizations, together with some government officials, took this matter to a domestic court in Mozambique. And this domestic court actually ruled that this debt that was lent by Credit Suisse to the government was illegal and illegitimate. And they were actually able to summon government officials who fled Mozambique to be repatriated back to Mozambique to face trial, and that is happening. We are seeing this now happening in Senegal, where the former president and his regime borrowed money, but it was not in the public domain. And now a new regime has come out, and through the help of the parliament and the courts, has unveiled a whole scandal of hidden debt. So I do think there are opportunities, there are good benchmarks out there where parliaments, judiciaries can take a greater stake in paying close attention to how government is doing its borrowing actions, but also lenders are engaging in our countries, because they too, particularly the commercial lenders, have very little interest in our development trajectory and our development advancement. All commercial lenders are interested in the return, in making sure their shareholders get paid back. I think the second one is around appreciating what type of debt instruments should be used for what development intervention. And I think this is linked a little bit to what Alex was saying, is that a lot of our infrastructure investment, while is important for economic development and economic transformation, is being largely financed by short-term loans. So you issue a Eurobond or you issue a sovereign bond that is only 5 to 7 years, and we know with public procurement and public contracting for such projects, those things take 3 to 5 years just to come online. And so by the time the project is starting, the debt is already needing to be serviced. And so this is where you have this challenge between a mismatch between a government development project and the debt financing instrument that needs to be used to finance that project. So I think having a greater appreciation on this is very important. And then lastly, on the national level, I think public consultation is very, very key. I think just like I think in Kenya, Kenya is a very good example of trailblazing public consultation on double tax agreements. I remember when I worked with Leonard and a few others at Tax Justice Network Africa, the judiciary played a very key role in dismissing a double tax agreement between Kenya and Mauritius because it did not follow the constitution, and then ruled that, you know, henceforth all double tax agreements that the government wants to enter into needs to be put through public consultation. And I think we are in this stage, as Alex and Dr. Kishan have said, where we need also the debt plans and the debt acquisition that the government is intending to be put in the public domain, so that citizens are aware of what is intended by the particular debt instrument, the terms and conditions, interest rates, which projects, how long is the duration of the payment, what does it mean if you cannot pay that, how much of the tax revenue is going to be allocated to paying these particular debts. I think we're reaching that stage in our context as a continent, not just as a country, but as a continent where also these issues need to be put on the table. At the continental level, the African Union Commission just about a month ago, just before the G20 summit in South Africa, adopted a common African position on debt. And within that, they are actually advocating for borrowing countries to come together and sit down and find ways of negotiating better terms and conditions for borrowing, but also better terms and conditions for negotiating debt restructuring. We've seen that the current process for restructuring is not very attractive. There's something called a G20 common framework that a few African countries have entered into. Zambia, Ghana, Ethiopia, Chad, and now we believe Zimbabwe. But this process is not working. It's extremely tedious. It's extremely protracted because not all the creditors can agree on how the debt restructuring needs to be done. So one way of doing it is to encourage our countries to adopt and start thinking through and working through this common African position on debt and use it as a way of doing collective. And I think just very lastly, at the international level, I think we need to understand the power dynamics that exist in the creditor landscape and move the decision-making power away from where institutions like the IMF and the World Bank, who are also creditors, are the ones deciding how debt is being tax matters. So I do think there are solutions when it comes to debt, right from the national all the way and oversight bodies to engage. And then just very lastly, I do think, and I want to, finish with a rephrasing of a quote by Thomas Sankara, is where he says, "If we pay, we die. If we don't pay, they die, and therefore we must not pay." When it comes to it's a piece that he talked about the debt crisis in Africa and who should be paying, because in the instance where debt is illegitimate, and I think here, the honorable ladies and lords have the ability to interpret what constitutes an illegitimate debt or an odious debt. Should we also then be debating at a continental level whether that debt should be repaid? If it has been borrowed illegitimately, illegally, or it has been misused for the wrong purposes for which it was intended. Should citizens be compelled to pay back that debt through regressive taxes, through a shortfall in funding of public services, through the trade-off or the undermining of our future generations in terms of education and health outcomes for illegitimate debt that is being borrowed today by governments across the continent. So there are these solutions that we can prefer to put forward and say, this is how we can actually manage the debt in a more sustainable but more comprehensive way. Thank you.
Thank you very, very much, Jason. And I like the way you paint that picture of who is really benefiting from this. And I think when we understand in whose interests these things are happening, we are able to see why probably human rights are not, observed in these processes. And so I would like to maybe hear from you, Leonard. So when we talk about taxes, when you talk about budgets, so what would it look like? Would a human rights compliant, like tax framework look like? What would it take for us to observe human rights if we raise our taxes, as we collect our taxes, as we draft our tax policies? What would that look like?
Thank you. If you recall, I'd mentioned the 5 principles. So in any tax conversation or process, those should take place. And if I take the question of participation from the position of the judiciary, you would see, in terms of participation, the judiciary would be speaking of avenues for petitions, submissions for amicus, discussion on the community or societal impact, and conversations in terms of public interest litigation, because that is I would imagine, the legal way of having that discussion within the process. If you go into awareness, this would be kind of catered in terms of reviews of legality, ensuring compliance, clarifying the executive obligations, because once they propose and then they are going to implement, how would the courts be ensuring those by its interpretations? And then in terms of just what sanctions have been made in the case of compliance. And then when you think of legitimacy, how do you reinforce the rule of law? Because sometimes attacks can come up and it's so quickly implemented and there hasn't been any proper examination. And you can see this from the conversations that were previously there about the housing levy and how it kind of played out. But the courts would be allowing for that. The courts would also then, in terms of legitimacy, provide public confidence once the interpretations are done, that truly, other than the procedures that are in place, that at the point of which now we have reviewed this law, that truly it can now go forward. It's kind of catered to these human rights-based approaches. And that also, other than that, there are that all processes kind of remain accessible and fair to the citizens. Now, that would be more of the technical work from your end, but one of the things you need to realize as Kenyans, as officers, is that particularly the question of tax is heavily driven by the executive. And so the judiciary as an institution needs to make its own space to fight for the fairness and the human rights obligations of all parties involved. Hence, from where we sit, we obviously look at lots of conversations like what will happen to the public participation law and how it will play out. And we expect that other than just the signing, the preparation in the legislature, the courts would also be interpreting a lot of things, not only nationally but also locally, because, For instance, public participation at the local level would have its own flavor based on those interpretations. So what would that mean? And so therein would be the conversations we have. But unfortunately, and this is just from very recent research, we are still kind of looking through the data. As I said, the executive drives the tax agenda conversation so much. Over the past 1 year, other than things like protests and maybe like talk shows, you find other entities, even in the news, are really driving it in a very minimal way. For instance, just by participation alone, how the courts participate or take part in the question of public participation and understanding it, the news reporting tends to look at that. And when you are just we've taken data for 1 year, and we are realizing that's only captured in about, it's almost as low as 2% of the news. But then in comparison with government, maybe 15%. So of that 15%, when you break it down, none of those aspects goes beyond 2%. But when you compare government, which is, executive, which is 53%, and the judiciary is at 15%, and then all other people, it's kind of like bundling in. Elements like the private sector would be relying on you to help them in this. And particularly over the course of 1 year, their voice has been considerably lost. We'd have to figure out why is that the case. Maybe the courts would be the ones to help us. And I think that's the way to think about those principles. Thanks.
Thank you very much, Leonard. Before we transition to plenary, maybe Dr. Gishana, do you have any call to action before we cross over to this other side?
Thanks a lot. I think for me, you'll allow me, my ladies, just speak specifically to what I spoke about earlier. Public-private partnerships. And the reason why I'm speaking about this is because, one, it's the new thing in town. But importantly, because all public-private partnerships have a life cycle of between 20 years and 30 years. That means we will be paying whatever mistakes we make, whatever assumptions we assume, whatever things we overlook because perhaps we think it's too technical, it's too complicated. Let the economist handle it. We are going to have to not only pay for it ourselves, but we're going to have at least a couple of other generations paying for the same mistakes that we'll be making at this particular point in time. Now, allow me to mention generally what I see as, one, we agree that public-private partnerships come with its own efficiencies, but it's not devoid of risk. It's not devoid of challenges, which I think we are in a better place, or your lordships and your ladyships are in a better place to be able to assist in terms of providing guidance. Now, we have a law that regulates public-private partnerships in Kenya, the PPP Act of 2021. Regulations were supposed to be, they've been formulated, the PPP regulations of 2022, they have not come into force. So a lot of the provisions of the Act are not yet operationalized. Now, one of the biggest challenges, as you would recall from last year, is the question of transparency, the question of secrecy, the question of uncompetitiveness in ways in which contracts for the provision of public services and the construction of public infrastructure are provided or issued under PPP arrangements. Now, does the Act provide for ways in which the public can be involved? Yes, it does. Does the Act provide for disclosure, mandatory minimum disclosure requirements with respect to project agreements? Yes, it does. Now, generally, in terms of statistics, we have about 36 PPP projects. 9 of these are already under, they've already been concluded, and they're now under operations and maintenance. 27 of them are in what you call a PPP pipeline. They're at various stages of development. And the challenge now is that you will realize A majority of these 27 were procured through a procurement method we call privately initiated proposals. Now, that is where the problem lies from a public sector point of view, because looking at the intergenerational impact of public-private partnerships, one of the things that you want to be very sure of as a Kenyan is that we are getting value for money. That as much as, yes, you are helping us offset the huge initial cost, we're not just allowing you to come and recoup all the money that you want to recoup, but we don't get really the infrastructure the way we want it, and we don't get it at a market price. Privately initiated proposals are those proposals which the public sector or the ministry or department of the agency does not initiate the development of the project. A private party sitting at their offices look at what your needs are, come up with the idea, and present that idea to you. Now, the challenge, there's no problem with that, because obviously one of the things that we appreciate is the government does not have a monopoly of ideas in terms of what social services to be able to provide and how efficiently to provide them. Now, the problem comes in where the entirety of the PPP Act of 2021 excludes crucial oversight mechanisms. And a central part of that is the exclusion of the legislature. Parliament does not have a mandatory oversight role insofar as the oversight of PPPs are concerned. These are multi-billion shilling projects that are going to be implemented over a period of between 20 and 30 years, yet we exclude critical oversight to ensure that some of these contracts, because they're privately brought, I don't go to Dubai, have a private conversation with an investor, they come, bring me a proposal, I approve it, it's implemented, and I get my own cut without necessarily ensuring that the public interest criteria is taken into account. Now, what needs then to be done is, one, the Constitution mandates competitiveness in all procurement systems. Now, when you look at Article 227, I think, all procurement systems, there are minimum requirements that are supposed to be met. Now, this is what the PPP Act of 2021 undermines by not making it mandatory. When someone comes to you privately in your office as a ministry or a department and gives you a proposal, there is no option for you to take that proposal out there for market sounding. Market sounding simply means saying, is there anyone out here in the public or in the private sector or corporates or corporations that have the same technology, have the same technical know-how, and are able to deliver this public service at a cost that is cheaper? Now, when we do not have that, it then means whatever is quoted in this privately initiated proposal is what is going to be approved and is what is going to be implemented. So essentially, therefore, yes, PPPs allow us to be able to do off-balance sheet financing of infrastructure and the provision of services, thereby facilitating the realization of rights. But there are also other things that needs to be looked into. For example, the Ketraco project, which was being implemented last year, comes with what we call, there's a tariff that is going to be added to electricity. Now, when it comes to now tariff-sponsored or tariff-based PPP projects, it means that we have to look at affordability of these tariffs. Are we excluding low-income households? Are we providing for various levels of standards or levels of service provision to ensure that if I'm unable to afford using the expressway, I have the alternative of using the road on the roadside, as much as there's much traffic? Now, the question then becomes is, how do we ensure that in the implementation of these particular projects, we do not push the cost? Because by design, PPP projects have already pushed the cost from the government down directly to citizens. As opposed to increasing taxes so you can raise revenue to be able to construct these projects, you've decided that private parties are going to bear the costs. Therefore, my call to actions I can see is we need to ensure that we provide a check on how these new and innovative products comply with the constitutional framework, comply with what we want in terms of public service provision, and that we do not look the other way while we have products which have huge intergenerational impacts. Therefore, we rely on you to be able to provide guidance, and we hope that we can be able to get that guidance to facilitate the realization of human rights.
Thank you. Thank you so much. I think we've been speaking a lot, and it would be good to also hear from our audience. So do we have a mic going round? Okay. Yeah, so I think at this point, you've heard from us. We see that there are some things that the representatives from the audience have a role to play to see how we address these issues. But it is good to hear from you as well. So I want to open this plenary. Questions, clarifications, or addition from the audience?
Okay. Yes. May we stand up a bit before we even appreciate our panelists and we go to the plenary. Judge Kamau, Jackie. Yes, please help us to stretch a bit. I can see that Ugali and Chele has done a lot of injustice to us. Please help us a bit.
So we catch the ball together, isn't it? Isn't it? All right, so you repeat after me. I catch the ball. Loudly, even you people. I catch the ball. I catch the ball. I put it here. I put it here. I pepeta. I pepeta. I catch the ball. I catch the ball. I put it here. I put it here. I pepeta. I pepeta. I catch the ball with both hands. I catch the ball. I put it here. I put it here. I pepeta. I pepeta. I catch the ball. I catch the ball. I put it here. I put it here. I pepeta. I pepeta. I catch the ball. Last one. I catch the ball. I catch the ball. I put it here. I put it here. I pepeta. I pepeta. Excellent.
A clap for Jackie. Yes, Jackie was my classmate and I knew she was equal to the task. Thank you very much, Judge, for giving us those few exercises. So let me thank our panelists for the very, very exciting the discussion. Now we know, and some of these realities, they are scaring, but we have to live with them. Thank you for reminding us about the social contract theory. We did it in the university those years, so it's good that we have reminded ourselves. This animal called the PPP, it is a new phenomenon and we are learning about it with time. We now know one or two things about it. The taxation and human rights, the debt distress. That is what is most worrying. But we want to hear from the other members of the audience. So this is now time for plenary. So we are going to open it up. Let us start from this side. Any questions on this side? This side, I can see Justice Rimo. Where is that roaming mic? Yes, please give it to. If there is any specific presenter that you are directing the question to, please you can.
Yes.
name. Yes.
Thank you so much, the presenters, for that very illuminating presentation, though also very scary. My question is, these debt management exercises and these very burdensome steps taken to try and avoid the issue of these taxes appearing on the tax books of the government. What is the legal basis for it? Is it anchored in any law? And if it is so, how could these actions be done outside Parliament? Because that is where the checks and balances are, and that is where the public participation bit takes place, to ensure that all the stakeholders and Kenyans in general have a say in what's going to happen to them now and in so many years to come. Thank you.
Thank you very much. Any other question on the second row? Yes, Judge Otieno Roakis. PJ Roakis.
Thank you, my classmate. I'm sorry I walked into this class late, but I need to understand. PPPs create on us an obligation as citizens. Why don't they deem them national debts? Just like securitization, when you securitize that 7 shillings on my fuel levy, it is a form of taxation in the sense that it increases my burden on accessing this service. Why do we keep arguing like this securitization is not a debt? Maybe I'm not getting it. I'm away from finance, but I need to be educated.
Okay. Any other on this? We'll first take the first round. Then, if there are more, we'll come back. Justice Maori. Oh, PJ, sorry, you'll be the next one. I hadn't seen your hand. Huh? Yes, Justice Maori. Yes.
Thank you very much for your very illuminating presentations. Mine is a very layman question. Because one, I know we have very sophisticated and experienced technocrats sitting in the highest, pinnacle of government. And my question is, in fact, I'll use an analogy. No normal woman will go out to buy heels, expensive heels for that matter, when the children do not have food. So my question is, what is the problem? Can somebody explain to me simply, what is the problem? Because listening to you, the whole thing doesn't make sense. What is the problem with us?
Okay, give it to the Honorable PJ. Okay. Yes, Judge Onkwane, come to you after this. Yes, Honorable
thank
PJ.
you, panelists. My name is Ogola. My question goes to Mr. Alex or Leonard, whoever feels more inspired to answer. In your submissions, you said that 7 out of 10 shillings go to repayment of debt. And you also alluded to a possibility that we can come to a point of no return where we are not able to pay our debts at all. 2 questions. 1, what happens when we are not able to borrow any more money? Let them answer. What will happen when logically there's no possibility of borrowing any more money? Then secondly, that's a wild thought. Kenya is known for harambes and what have you. Do you foresee a possibility that we can say that let's have 10 million Kenyans who are employed to give us 50,000 shillings or 100,000 shillings or even 10,000 shillings? Yes, national fundraising exercise to pay our debts. Is it a possibility? And even if it's not a possibility, is it something we can think about? Because there are so many people in this country. If we are required to pay 10,000, others can just pay 1 million. So that we agree that we have been a country of thieves, but from a particular point, we want to go forward. Is it possible to have a national conversation on Harambee so that we can contribute to pay our national debt?
Thank you very much, PJ. Yes, Justice Mushemi, just because he's just near there.
For me, I think I've had that conversation of odious debt, mostly from Jimmy or Jeke and others. And because it has been happening not only during this regime, even before other past regimes. Has anybody gone to court to file a petition trying to help Kenyans not to pay those odious debts? If they are not authorized by Parliament, I believe they are odious. Thank you.
Yes, Judge Frida Onkwani, sorry for the delay in giving you an opportunity. We can now go.
Thank you. Thank you so much, Judge Lucy, for this opportunity. And I wish to thank the panelists for their very informative discussion. My concern is closely related to what PJ has said and Judge Florence Mushemi about the odious debt. We are grateful about this, it is a newspaper or a newsletter, the People's Audit. I will take time to go through it, but just before I do it, my question goes to any of the panelists who feels inspired to talk about it. About the odious debt, have you taken stock of what amount of debt we have and how much of it is odious or illegitimate? And from your talk, it would appear that Kenyans are literally just drowning in debt. And some of these debts, the manner in which they are being obtained is quite, would I say, questionable, or sometimes just sneaky, sometimes surprising. As a judiciary, there's very little we can do unless a matter has come before us to discuss, really look into the issue of how much debt we have and whether or not we should be getting more. So my question is, as Judge Mushemi said, is there really an end to this? Because we hear also of debt ceiling, that now, okay, we've approached the debt ceiling. So are we past the ceiling, or does the ceiling keep on moving? What really will the ordinary Wanjiko on the streets do about this? Because ultimately, they bear the brunt. Thank you.
Okay, how many others, so that we are able to make an informed decision on whether they should answer those ones first? Should you answer those ones first? Then we take another round. Yeah, so that they cannot get confused at some point. Judge Kamau, I'll come to you after that. So any of you can answer, the ones that you feel inspired.
Thank you. Let me start. Justice Ogola, I'm quite inspired. And I want to start from your question number 2.
Just 1 minute, if you don't mind. Yes. Yeah. I am told one of those questions that has been asked on odious debts, it's a live issue in court, and there's a bench dealing with that matter. So I don't know how we are going to handle that one, because we should not be discussing it when it is a live matter in court. Yes.